is a company, my lord, that during the process of its existence, there were some amalgamations and mergers by which the name of the company has been changed, my lord. And that changes I have to bring to the record of this court, my lord, by changing the, my lord, cost title and that, my lord. That IA will file, my lord, for changing.
That I will file.
We'll file an IA, my lord. And my lord, matter may be listed, my lord, on 24th of November. In the meanwhile, we will, my lord, do whatever is to be done, my lord. My friend is here, my lord. She
24th of November.
November, my lord.
Item 29, na?
29. And my lord, there is another prayer, my lord. In the IA, my lord, attached.
Let me get it's amendment cost every in the meantime, you can file your I also.
My lord, and my lord, there is an IA here. In that IA, there was an interim order, my lord, that will be continued.
In I interim was there?
Yes.
2411, we have fixed.
2411. I am Dipto.
Wait, please, your lordship. My lord, I beg to mention item 17, lordship. I have due consent from the other side. Let this matter may come after vacation, lordship.
17.
17, lordship. We are for the appealant.
You are for the appellant. Have you taken consent of the
Lordship, I have due consent from the other side.
And one I is also there. What kind of I is this one?
Lordship,
I is
regarding the stay, lordship, both the matters may come up,
together.
lordship.
After vacation, will you give?
After vacation, lordship.
The same order. Consent of the other side. Then I consent for the
First week of November, if possible, lordship.
because I will over the will be after.
May please, lordship.
Your Lordship, may I mention item number 30? I have come from Calcutta High Court for that.
Okay.
So if that may be taken up at 2 or first item of hearing, I shall be very grateful for that.
Acha, you're for the appellant or
I'm for the appeal.
you're for the appellant? Have you met the respondent side, other side?
Yes, yes. You are informed. Yes, yes, yes. As per your Lordship convenience, at 2 or first matter of the hearing matter. There is already a passover now, so pressure is less.
Okay. We'll try it.
I'm so
maybe at 2 or as soon as it possible.
I'm so grateful.
May please, lordship.
But the other side may be informed accordingly.
They have been informed. Now he is going to inform again that we have.
Oh, you're
mentioned.
for the respondent?
No. He's assisting me.
Yes,
in this case.
you.
So he'll be informing him.
Ah.
We have already informed, but now we'll inform that we have mentioned this matter.
Oh.
I'm so grateful.
May please, lordship.
Hey,
May please, lordship. Mention item number 26, my lord. For hearing, my lord.
yes,
So, my lord,
fixed for hearing.
opposite to get this adjournment and fixing a hearing, my lord. I'm the appellant.
You're for the appellant.
Yeah, opposite side is that he also told me fixing
You're
in the
taking
month of
consent.
November, 4th of November, my lord. If
4th of November.
a hearing day, my lord.
Otherwise, it's a hearing day,
Yes.
Tuesday.
Tuesday,
You want a fixed date?
fixed date, my lord. Because it is the old matter. I also interested. He also put. Today he has some difficulty. I have some difficulty.
Okay. It's same with the consent. 4th of November, you are saying.
Much of next week.
Please, your lordship, I beg to mention item number 13, lordship. I may be allowed to withdraw this petition, lordship. Item number 13.
Yeah, it was a bail application.
Yes, lordship.
You want to withdraw this one?
We do.
You are Mr. D.
City alone.
Yes, Mr. D. Then petitioner also participate. Submitted the instructions of this right. He wants to be rare enough to dispose. Okay.
File approve.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 18. Lordship, I am praying for an adjournment today. Let the matter come up after vacation, lordship.
Otherwise, it was for the, in order column.
Lordship, in this case, we are supposed to file substitution petition, lordship.
So here, there are 1, 2, 3 ayes are there, and then, for the other side, Mr. H.R.A. Chaudhary has already.
R. Chaudhary, R. Chaudhary.
Name of H.R.A. Chaudhary is also there. Now, MS R. Chaudhary is,
Lordship,
have you
I
informed?
inform, I have already informed.
Yes, you sit to the other side, they done it once. What is your good name?
Edas,
MS A, that's 8.9, so. After vacation,
lordship.
please the matter immediately after vacation, and then the date will be fixed.
Yes, please, lordship. Lordship, in item number 4 and 5, mainly at item number 5, we had filed an IA, your lordship. Lordship, the IA is just for permission. to
Now,
withdraw
just
the-
a second. Yeah, if you have filed I for what?
for permission to withdraw the deposited amount, lordship. Yes, please.
But these we have already identified for mediation.
Item, yes, my lord, item 4 and 5, I'm having for insurance company, my lord. It is, it's for mediation, my lord.
Ah.
And it may be fixed at the local adult, my coming local adult, my 13
No
December. my
Kadara
lord.
will be on
13 December in local adult, my coming local adult.
13th of December.
Yes. Both the matter, my lord.
Lordship, let the IA be disposed of, and it may go for mediation. It is, the IA is just for a permission so that the amount can be taken by the applicant.
No, if there is any, I don't know, is there any, why there was no order for release
one?
was
I-
not there?
I don't know, my lord.
No, you have not filed yet.
Yes,
Yes, my lord.
No, yeah.
we have filed the IA, your lordship.
Huh.
We had filed it on 22nd of this month.
No, but it had not been listed.
It has not been taken, your lordship.
Huh.
So I'm praying to call the records.
Most probably those will not be, today not be possible. May not be possible.
Lordship may take
Tomorrow
up the
we have
matter
some
for,
very, lots of pending works. We are not in a position to say everything.
lordship, tomorrow, maybe tomorrow.
No, tomorrow we are not at all.
Then your
Let's do
lordship,
do one thing, let it be immediately after
Or
vacation.
it
then.
may be an adjourned after vacation, my lord.
But in this case, we have identified for, actually for mediation. So
Mediation,
in
yes,
fact, in that case, what you want to submit?
We are ready for.
If suppose if money is already there, it's
Yeah.
okay, no question at all. Will be no problem at all. Suppose money is there, if they agree, then matter may be settled and deposited money can be withdrawn.
Yes, my lord.
Because these are the cases which have been identified for the mediation, for referral. So let your party be informed. Will take steps appointing a mediator. In that case, before the mediation also, if any settlement is there, then obviously money is with us, raised before the raised. So it can be with. I think will not be any problem. In the meantime, your eye is there, it may come up within this meeting. So what will be your convenient date if you send it for mediation?
Let it be, my lord. They are the dispose of IA.
No,
As
I
we
is not
discussed,
here. I will not,
They have filed, my lord.
no, we are not calling it.
Then, my lord, it may be fixed for local adult, my lord.
We are sending it for mediation only.
Only medicine.
If it
Let
mediation
it be.
fails, then definitely it will come before this court only. Do you
Okay.
have any convenient date? Do you have any convenient date?
14, 15, okay. After the
After
vacation.
vacation?
Yes, your lordship.
You are MS?
I'm appearing on behalf of B. Gogoi, Mrs. B. Gogoi.
B?
Gogoi.
Oh, you are for the respondent.
Yes, your lordship.
Your good name?
A.N. Hussain.
A.M. Hussain. Hard MS A.M. Hussain. Learned council appearing. Oh, no, no. Hard MS L. Sharma, the learned council for the readers 4 and 5 same. Learned council for the appellate. Also part Ms. A.M. Hussain, the learned counsel appearing for Mrs. B. Gogol, MS B. Gogol, for the response. Uh, Considering the submission made by counsel for both sides, let the matter be sent for mediation. And the parties are accordingly directed to appear to the mediation, mediator on 14 Jan 2025. The State Legal Services Authority and the High Court Legal Services Authority will take necessary steps in appointing the mediator. So High Court Legal Services Authority as well as the State Legal Services Authority will take necessary steps in appointing a mediator. In the meantime, if mediation is successful, it's okay. If it is mediation is even not successful, your matter may come up on court.
Yes, sir. God bless you.
May I please, your lordship? Lordship, in this case, lordship, the petitioner was arrested on 3/7/2025, lordship, and as on today, lordship, 84 days. Lordship may peruse the order,
3/7/25.
84 days, lordship. Lordship may peruse the order dated, lordship, 17/9/2025, page 33, lordship. Some other co-accused approached before this honorable court and lordship after perusing the case diary, lordship, granted bail to them, lordship. Page 33, lordship.
No, your petitioner's case is, you tell that your petitioner.
Lordship,
Your case is, what is your case?
lordship, FIR,
That
lordship,
is case for co-accused, and what is your case?
lordship, FIR
So
would
your-
find,
your
lordship, page
petition was
11.
Earlier rejected.
No, lordship,
No,
no,
not rejected. Huh? His petition earlier rejected,
no, lordship, no.
and then they want to submit.
His submission is that co-accused were granted bail by this honorable court.
On the ground of length of detention, lordship.
That is a submission. But my lord, after perusal of the CD matter. That is the thing.
Lordship, statutory period is over on lordship on first, lordship, October, lordship. And there is a vacation also there, lordship.
Pardon?
No, vacation on lordship, 8 and 9, lordship. Yesterday notification published, lordship,
8 and 9.
8 and 9, lordship.
8 and 9. Yes, Bush. Only length of detention can be considered. Only length of detention can be considered.
My lord.
Otherwise,
Because
no,
my
we
lord,
don't
in
have.
earlier, my lord, there is, when my lord, co-accused was granted bail, my lord.
Ah.
There, my lord, that is one was on that day, my lord, that is on 17.
For one is 92
Was
days.
92 days
Ah.
and petitioner number 2 for 77 days and 3, 4, 5 are for 79 days.
79.
Otherwise, my lord, all are FIR accused and implications are there. Most probably he is because I cannot say right now because CD is not available. But my lord, that time after perusing the CD, it was pleased to grant bail.
Part Mr. Ayush also did an account for the petition and also part Mr. Petition.
And my lord, one thing, my lord, in that case, my lord, was there, my lord, because my lord, that point of time, my lord, that is, my lord, in the, my lord, para 5, my lord, it was stated, my lord, that, my lord, one thing, my lord, which is considered by your lordship is that the learned PPP has submitted that in this regard, it is a fact that the petitioner number 1 is in custody since 92 days, but till date, IO could not submit the service. So, my lord, may I take one telephonic instruction whether on this today, my till today, whether surset is filed or not. Because that point of time, surset was not filed. CD was available with
Lordship,
us.
as per my instruction, lordship, charge not yet filed, lordship. And CD is lying in the office, lordship, probably. As per my instruction, lordship.
For why? For in connection with other matters
Lordship,
or
in
what?
connection.
Why it is lying in this case?
Lordship,
Because
the
co-accused bail is also considered by this court. I don't
Lordship,
know, as per your submission and
Lordship.
order speaks.
Lordship,
the
one
petition-
co-accused Lordship approached before the learned court below Lordship, wherein the
CD
the
was
date was
called.
fixed Lordship, day before yesterday on Friday Lordship, and the IO submitted that the charge sheet was lying in the High Court Lordship.
Charge sheet.
No Lordship,
CD.
case diary Lordship, case diary Lordship. So probably it is in the office of the Lordship, public prosecutor.
Maybe. You may take that.
We take instruction, my lord, whether such series is filed or not, because my lord, that was reflected in the earlier order, my lord.
Okay, for time being, vacate.
Lordship,
My-
deeply obliged.
Wait, decision lordship. My lord, a second application lordship. Earlier rejection order, lordship may kindly find at least 16.
What, the forging of the photographs and this for
Yes.
admit card and all.
Yes, lordship, yes.
Okay, then we at best we can call for a, is there any new ground? you have
Yes,
taken?
lord, new ground is petitioner's wife is pregnant, advanced stage lordship.
That
Six,
is your new ground.
yes, 6/9 is the date of delivery. I have annexed the medical papers.
What can I do for that?
Lordship,
I'm sorry
he is
that
the
he
only,
is there, but-
he is the only person to take care of his wife. As well as his mother. His mother is also under
avoid-
in
He have
GMC.
avoid himself from doing all these things now.
Yes, lordship.
Should not be involved in this. Okay, we are calling for the case diary because it is a second bill application. We don't have any alternative. Obviously, it will be after vacation.
Right.
Guess person, any date can be fixed.
16,
16 is called.
My lord, then we
Maybe
are-
15 now.
15.
CDP call for 15. We are calling for the case
Sure.
diary.
Obliged.
May previous lordship. Here in this case, my lord, the sole respondent has expired and we have filed a IA.
So
So-
it's going to expire.
Yes, my lord, already that is pending. Notice has been issued. Your lordship may kindly peruse office detonated 16/3/24, passing IS 79. IS 79.
Sixteen three or 743.
16th office note.
Oh, acha, office.
Yes, my lord.
This is the petition for substitution.
Yes, my lord. That is accompanied with a petition with for setting aside the abatement also. IS 9 is the
It
accompanied
was, it
petition.
was within the.
In both the petition, notice has been issued, my lord, by the common order, passed in 79. But thereafter, nothing, no service report is visible on the record, ma'am.
In which mode you have taken steps? Through registered.
Both by register as well as by
As
usual,
usual.
yes, ma'am. Or may I take first steps, my lord, because it was taken in 24.
Now say it is almost one and
Yes, yes, ma'am.
almost about to be 1.5 year or
Yes.
more than 1.5 year later. So I think better to take a fresh steps. Otherwise,
both
we
ways.
are not in a position to say
Oh.
anything.
Yes, ma'am.
And who was the sole respondent?
Previously, my lord, the respondent was represented by Mr. B.T. Deka, the council. At that time, service was complete.
So now the legal layer is only one, Miss.
Yes, my lord, only the sole respondent that has to be substituted.
I. Mr. Mr. K.
G. Jalan, my lord.
Tija, Mr. Tija. The learned counsel for the appellant. And for the cases identified for the referring to the mediation, but it is submitted by Mr. Chalbi that the sole respondent had already died. And to substitute the legal heirs of the respondent, they have already filed. one I and one interlocutory application, wherein the notice was also issued to the respondent who was to be substituted in the place of the sole deceased respondent. However, from the office note that is 16/3/2024, it depicts that sorry, but however, after the note on 16/3/2024, there is no note from the registry in regards to service of notice on the respondent. In view of this, the appellate is hereby taking by steps the respondent and to register it and individual process. This matter immediately after vacation. So due to absence of the sole respondent, the matter would be set for mediation.
My lord, in both the years,
Yes,
79 and 9.
79 and one more is
9.
9 is also there. One more.
No,
is
that
there.
only 2 is pending. That is stay. For substitution is 79
Ah.
and 9 is for abatement. Setting
Yeah,
aside of the
correct.
abatement is fine.
And one more I is also there. 201. What is
That
it?
is what for stay. That is stay is there.
Stay is there.
Yes. Obliged. ma'am.
2 I. Yes.
In this case, they have deposited 50% of the interest without,
Okay, this is.
we have received the amount.
mediation. Forget about this. I'll get identified for mediation. This is identified for mediation.
That can be present at mediation first.
Provided they have already deposited the amount. If the final award has been passed as per that order, my lord, with the payment of 7.5% interest, then we are agreed.
No, I'm not sitting as a
Yes.
mediator.
That
I'm
will-
not sitting as a mediator. I'm saying that it is identified, the case is identified to send for mediation.
If
If
they are
it is
not.
agreeable to
Yes,
you,
sir.
if the party is agreed, then we can send it for mediation.
Plus,
In that case, suppose what the amount is already been deposited, that can also be there. Because money is still lying with the registry.
We have received.
You have received,
50%.
it's already been
50%.
released.
50%.
That
Oh,
is,
then what is the submission?
my submission is, as per order, they have to comply with that order.
We are not confirming because we have prepared this appeal. The judgment is something wrong.
My
Lordship.
lord,
We are-
hearing.
So we may fix for hearing if they are not agree to go for mediation. Lordship.
No, I'm not following you. They have deposited 50% that has already been withdrawn or
Yes.
released in your favor. Now case is pending because they raised some issues.
Yes.
That's what. I'm just saying that if it is possible, if there is a probability of mediation in the present case, then it can be sent for mediation. That's what I'm asking.
Then, we.
Now,
One-
compliance of order, etc., will come later on because they have filed the appeal. They have preferred the appeal. Compliance of order will not come in.
Yes, my lord, but they have taken grounds, some grounds, my lord, to reduce the amount and other.
That's what they have challenged the quantum. That is the case.
One attempt may be made in mediation. Lordship. If fail the mediation, then again it will come for hearing.
First question is they have challenged the quantum. As per them, the quantum it should be reduced.
Yes.
That may be their case. So if you will get the opportunity to discuss the matter before the mediation or mediator, you may come at arrive at this decision. Okay, that's what I'm
At
saying.
first, send to the mediation. Then. Otherwise, we have to come back again.
If mediation
If
fail,
it
they
fails,
If
if it
mediation
fails,
fails.
then definitely it will come for hearing only.
Right.
If it fails. Heard Mr. J. Kalita, the running counsel for the appellant. Also heard Mr. D. Bora.
Bora.
D. Bora, the running counsel. You are appealing for the claimants.
Claimants, 1, 2, and 3.
1, 2, and 3, the respondent claimants. Considering the submission made by land. This court is of opinion that matter may be sent for mediation. Accordingly, the office of the State Legal Services Authority as well as the High Court Legal Services Authority will take necessary steps in appointing a mediator. Those two the parties are hereby directed before the mediator. Your preferable date, any date
Yes, Lordship, after vacation, Lordship will keep
after vacation, any
Last-
date?
After position.
15/10, 16/10 will do.
15, 16, I am available. But in the next week, I am not available. 15, 16, I am here.
You are here. Okay, then 15/10.
15 October.
If it's up in any reason, if it fails, mediation fails, then it will come before this court, then we can discuss, or it may be taken up as a hearing can be. No issue.
That is 15, no?
15/10 we are fixing.
15.
Parties may be directed to appear on before the mediator on 15/10. All the other steps will be taken by the State Legal Services Authority as well as High Court.
Problem.
Please, Lordship.
Well, we try. Both the cases, same cause of action manner.
Cause of action. Cause of action.
Same
From
accident.
same accident.
Pardon?
There is a 2 death case. 6 and 7, 7 and 8.
Death
So my
case.
lord, yes,
Out of same state.
same accident, out of same accident. My lord, maybe fixed on 15. We shall try.
For mediation or?
Yes.
Same for
Mediation.
Sit.
You try
15/10.
We shall try, madam.
same order. Oh, Mr. R.C. Paulus. You, Mr. K.U.
Yes.
Emmett. So we are sending it on, sending for mediation on 15/10. Ask the
15/10.
parties to have same order.
Both the cases.
Let's see if it doesn't reach to any settlement, then it will
Madam,
come.
madam.
For hearing.
Madam, both the case,
Yes, both the matters.
much.
7. नाम तो क्यों दिया है? नाम बिला की दी। ये बटन लगाएंगे ऐसे। Right, yes, you are
And for the appellant.
for the
Lordship.
appellant.
Yes,
Other
Lordship.
side, where is the other side?
Other side will not appear. On the last occasion also, when there was a delay in filing this present appeal, in that initially one lawyer appeared, thereafter no one appeared. So delay was condoned by this honorable court and the appeal was numbered. Thereafter, when the notice was issued, we have taken steps also, Lordship. No one turned up.
But notice, second time when you have in the appellate, when appeal, after the admission of the appeal, you have taken steps.
Yes,
After
Lordship.
admission of the appeal,
Yes, yes. I have.
or it is received by the office in charge of the respondent. Office in charge of the respondent. It was served through office in charge of the respondent.
Huh?
Office in charge of the respondent. As per the office note dated 22nd of September,
Yes, sir.
service report has been received stating that the notice had been received by the office in charge.
He is an employee of NF Railway.
Oh,
So there he received the notice. It was a notice he received because she is residing in the same quarter of the respondent lordship.
acha.
And he is not. paying
Is
when
there any, as per you, is there any probability there for any conciliation, mediation?
She is ready for that. She is having 2 daughters, lordship, and she is finding financial hardship. She is a housewife, although she is staying in the same quarter. So, and the appeal that matrimonial ex parte order was passed in the divorce proceeding, and that order he has placed before his authorities. And she is residing in the same quarter which is being allotted to him. So notice
So now
not,
she is still residing in that.
he is still residing with her 2 daughters. And daughters also could not pursue the further education because of financial constraint, and he is not supporting them. So she is ready for any amicable settlement. Otherwise, the appeal should be heard on merit.
Mr. S. Day, name of Mr. S. Day was there. Mr.
Initially, he was there, lordship.
Acha.
This is the reason his name is reflected. Initially, he was there. Then during the IA only, when the delay condonation petition was being heard by this honorable court, subsequently he said that he is no longer there in the, so he has, thereafter courts on his own merit has allowed. After the arguments allowed the delay condonation and then the appeal was numbered.
Hard MS Coast, legal aid, your legal aid.
Legal aid counsel.
Legal aid counsel for the appellant. And post from the office note dated 22/09/2025. It is seen that the notice has been received by the office in charge of the respondent. However, no one has represented the respondent. Due to absence of the other side, the matter could not be sent before mediation. Okay, then
Yes, my lord, scan copy receipt, my lord.
Ah.
My lord, I need some time.
On the last occasion, the scan copy was received. Since
Help, my lord, I will.
Since the matter, court wanted the matter to be in the trial court to be in the evidence, stage, today is the date of evidence there. For that the matter was pending. 103 days, lordship.
you want some time,
Today itself, I need some time, my lord.
just for time being. It's-
Please, lordship.
Yes.
Also, as on today, 88 days, lordship.
Pardon?
88 days in judicial custody, lordship.
88 days. Yes, what is your position?
My lord, otherwise, my lord, city received, my lord. Filed one objection also in this regard, my lord. They are called bail objection. My lord, otherwise, it is an organized crime, my lord. The robbery, everyone is connected, my lord. Sufficient materials are there, my lord. These are the two persons, my lord. That is a one, my lord, Shahjahan Ali, that is petitioner number 1, Hafizul. My lord, that is when, my lord, that is the driver of the truck was kidnapped, my lord, at that point of time when he is getting the goods, my lord, at the night. My lord, that is the occupant of that car who is involved in this robbery. One is, my lord, is a driven by, that is the one, petition number 1, my lord. Other is also very much involved. Now, because, my lord, in the gang, my lord, as it is a, my lord, organized crime, many other clues are there maybe. So, my lord, because of that reason, my lord, they are not able to, my lord, find the search. Still, the investigation is going. Otherwise, sufficient materials are there. But admittedly, my lord, today is 88 days.
Lordship, once it was rejected on this ground, Lordship. Already once it was rejected, Lordship. I'm today purely on the length of detention, Lordship. 88 days, Lordship. Sufficient time for investigation, Lordship.
What to say, these are the all are this are the organized crime in fact.
But can you produce the city, my
Obviously,
lord?
it is 88 days that is there.
Okay.
They are also involved in the similar kind of offense earlier also. You are Mr.
M. Islam.
Heard Mr. M. Islam, Lieutenant Counsel for the petition. And also heard Mr. K. Fusha, Lieutenant PP, appearing on the. This is an application of the section 20 in connection with source. Is diary receipt. Is submitted by Mr. Islam that present two accused petitioners are used and they're not involved in the alleged offense. However, they are in custody since last 88 days and hence further custodial interrogation may not be required in the interest of investigation. How to support the accused petitioner also. How many petitioners? 2.
2, Lordship.
For the accused petitioner are also ready and willing to cooperate in the extend their cooperation in the further investigation of this case if they are granted with privilege. Next part, Mr. Bosher, the learned additional people submitted in this paper that it is an organized crime wherein both these petitioners are also involved and sufficient incremental materials are available against the petitioners. but it is a fact that the investigation is still under process and IO could not furnish the charge sheet. And the probability of filing the same within 2 or 3 days is also not possible. It's better hearing this submission made by Learning Constable. And without going detail into the merit of the case, only considering the length of detention undergone by both the accused petitioners and the further custodial interrogation may not be required for the purpose of investigation. To whose satisfaction this one is for?
Pardon?
To whose satisfaction?
learned CGM board with that.
What at
Yes, Lordship.
CGM board? Okay, we consider only the length of detention. Earlier it was rejected, in fact, lots of matters are there in fact.
Because
It will be similar kind of.
my lord, many things are coming out because of that they are not able. And these are organized crime, my lord. Even they are able to, my lord, that
Investigation
is
is
recover all that car also, my lord, which is involved.
Yes.
Yes, everything, my. And this is about organized way, my lord. One of the accused is he is a habituate of, and earlier also all these things.
Mm. Mm.
So one by one, things are coming.
Yes. May take some time.
Yes.
May I please? Lordship, here CD is received on the last date. CD was received, Lordship.
My lord, CD is available, my lord. Voluminous, my lord. Today I will go to need some time, my lord. What's the
Lordship,
matter?
after some time, maybe. Because on the last occasion, CD was received, Lordship. On the last date, Lordship. Because this bail application has been pending from since 2024, Lordship.
This bill?
Yes, Lordship.
What? 2024?
Because CD was not coming. Interim was granted on 19/1/2025, Lordship.
You were on early interim.
Interim, Lordship.
Or my lord, immediately fix after vacation, my lord. As because my learned friend's client is already in interim, my lord.
Lordship, recently, Lordship, the Honorable Supreme Court has passed a
I have
judgment
it.
on, yes,
I have done.
that applications regarding personal liberty cannot be kept pending for eternity, Lordship.
So that is
So Lordship,
already
may,
acted,
if CD is available, Lordship may take up after some time, Lord, if he is
Okay.
we will.
obliged.
So time being very early. Huh? 84 to roll na I should 84 days. तो भाई के टाइमिंग में प्रॉब्लम हो जाए हमारे पास प्रॉब्लम होते हैं कल का अपने का से देखिए हाँ हियरिंग उठने के लिए ना होगा वो आई लो हमारा प्रॉब्लम होगा
Time being. Your item may kindly be passed over for the time being. So Das is on legs, that's why I'm.
See, at 2 we have fixed.
Not at 2, after
two
some time.
hearing matters.
After some
So
time.
if it is that matter starts, then other matter will not reach.
No, after some time, my lord. Just after.
Or at least
Respondent.
You are for the respondent.
Right.
Just MSP Das was appointed as a legal aid.
Legally,
Is it transfer petition?
transfer petition. I'm objecting also. I have filed objection also, Lordship.
You file your objection.
Objection.
It's a basically a matrimonial case or what?
Material for divorce, Lordship.
Oh, non-application call for the petitioner. Heard Mr. J. Abbas, still on a constantly respondent. And it is submitted by Mr. Abbas that he has already filed his written objection, which is on record. Let the matter be listed immediately after petition as an date fixed by the registry. Is there any stay order is operating? No,
Stay order, I think.
I am not
Last
finding.
order.
No. I don't think it is any day stay. Oh, acha. stay is operating,
Initially, there was stay, I think last
so that
order.
is still operating. It is immediately after vacation as an entity fixed by the registry, till next date of listing, in order to have it till next. Okay, we're listing it after vacation.
Lordship.
Otherwise, it could have been heard and disposed of today.
Lordship. Obliged, Lordship.
May it please, Lord. Also, this is a make appeal. This is has been preferred against a judgment and order dated 13/6/25. Okay. Passed by the MSc Golaghat.
What is the basic ground for your this appeal?
Also, the grounds were mentioned in paragraph 8, 9, and
No,
10.
no, not grounds. As otherwise, you're agree with the quantum, any other
Yes, yes,
legal
sir.
issues or what?
The quantum.
Quantum, mainly on quantum.
And basically, Lordship, the vehicle which was involved, we are saying this is not a vehicle because the vehicle is a different vehicle. They were stating the witnesses. And the CW also, they have stated the name of the vehicle is different, and whatever they have seized, the police has seized a different vehicle. So that is also there in the grounds.
You are Mr.
PM Talukdar also.
PM. I heard Mr. PM Talukdar, the learned counsel, the appellate. This is an appeal under section 173 MP Act, challenging the judgment and order dated 13/06/2025, passed by member MSCT Golaghat in MSc case number 142 of it. It is submitted by Mr. Talukdar that they basically the challenge, the judgment and order is challenged on the issue of quantum, as well as there are some other legal and some other legal issues are also involved. Appeal is admitted. Issue notice to the respondent to registered alien as we have proceeded. So who is the respondent? Respondent is the claimant?
Claimant. Yes.
Claimant,
Yes.
only claimant.
Yes.
Owner, driver, they are not the party.
No, they are not.
The respondent claimant to registered alien as their process. And also call for the DCF. List matter immediately. What is IA for?
The I for stay also, stay of the judgment.
I is for stay. Do you, are you ready for payment any 50% and all?
Lordship may kindly pass the order. I'll-
Pardon?
Lordship may pass appropriate order, then I'll,
No, I'm just asking,
in case,
you are ready for
The-
payment of 50%
in that case, Lordship, I may be heard.
after their evidence?
Yes.
Issue notice. Code. So in I also we are issuing notice.
Yes.
So that both the matters may come up together
Yes.
and we can hear it.
Yes.
But as per your information, is the execution is there or it's not?
Right
Not
now,
even-
I have no instruction on it.
Because your stay is not operating, that's why I'm asking. Okay, then let us come the matter.
Obliged. Valeu.
After vacation. After vacation. Two. Non-appearance call for the appellant. List the matter immediately after vacation as on a deputy fixed by the case. Oh, you are here.
32 minutes.
Acha. Yes, Mr. Sahu, what is the case?
This case, my lord, against the reversal judgment and decree, my lord.
You are the appellant.
I was
Defendant.
the defendant, my lord.
You were the defendant.
Defendant, my lord. And
So-
suit was for partition, my lord.
Initially, it was in your favor or what?
Trial court dismissed the suit. That was in my favor.
It was
They have
dismissed.
preferred, yes.
Hmm.
They have preferred
Appellate authority.
first appeal.
Hmm.
And the first appeal court has reversed the degree and decreed the suit for partition.
Acha.
So against that I have come, my lord. Number of fact was that the grandfather of the plaintiffs was the owner. Actually, land was ancestral one, no doubt. That is an admitted fact. Now, my lord, grandsons has come that the land was the ancestral one, but our name has not been mutated. In fact, the name of the grandfather of the defendants was mutated. So they did not know about this, and their father never sold any land to them. Therefore, they sought for, my lord, filed this suit for partition with consequential reliefs.
No, otherwise, whether you are also the family member, no.
My lord?
You are also the family member of the plaintiff.
Yes, the ancestor. Yes, ancestors was common, my lord. And third generation has come before the civil court seeking partition. Third generation.
Seeking partition between whom?
Below partition between the plaintiffs and the defendants.
Then what is your objection regarding the partition?
My lord, yes. If your lordship come to the appellate court judgment, may I read the relevant portion, the basis on which the appellate court has granted the decree, my lord. That is at page 71 of my additional affidavit, my lord.
71.
One of my additional affidavit. Before that, appellate court has discussed all the evidence and laws. And paragraph 21, this is the basis, my lord. May I read, my lord? Thus, in the instant case, the defendants are claiming title on the suit land on the basis of mutation. As has been found above, the Honorable Supreme Court has clearly observed that mutation does not confer any title. To prove the title, the defendants have failed to prove any purchase document. Thus, on analysis, the evidence on record, it is held that the plaintiff's appellants are in possession of the suit land as co-sharer, and they have right title and interest in respect of 1/3 share of the suit land. Accordingly, the point is decided in favor of the appellant's plaintiff's. Now, my lord, this finding, my lord, itself is a perverse one. Why, my lord? If your lordship come to the memo of appeal, my lord. Memo of appeal. At page 34, this is the trial court's judgment, my lord. And at the bottom, my lord, Exhibit B. Can you see Exhibit B? The copy of, my lord, Patta. Patta was there, my lord. Patta was in our favor. That was not discussed at all. So, my lord, this finding is completely, my lord, perverse.
But if you claim the that you have the right over the land through purchase,
yes,
you are not able to furnish anything in that way.
Purchase was there, no doubt. But later on in the year 2000,
as it is observed in the para
yes,
21,
yes.
that means you could not produce anything.
Anything means except the mutation, I could not prove anything. I could not produce anything, of course. But, my lord, in the year 2009, that Patta was given in my favor. Patta was given in my favor, and that Patta has to be challenged. Now, Patta, where that has to be challenged, my lord? 154 of this regulation, my lord. If lordship has the book.
Borua. Assam Land and Revenue.
Land revenue regulation. Regulation 154. Regulation 154.
154. Yes.
My lord,
Hmm.
that the validity of settlement that cannot be challenged before the civil court, my lord. Because rightly or wrongly, I have been given patta, my lord. So when trial court has given them right title interest, meaning thereby he has set aside the patta. So this is one aspect, my lord. And my lord,
But now
That-
question arises,
My
your
lord.
name in the patta.
yes,
On what strength your name has been mutated in the patta? In the, on the strength of purchase, on the strength of gift, on the strength of
no, when settlement was there, they have given me patta on the basis of possession as well as title. Possession as well as title. That was given long back, my lord, 2009. Without setting aside that patta, they cannot challenge. 154 has,
Was there any prayer for no?
my lord, no, nothing. Nothing was there. And secondly, my lord, from that relevant portion, it seems to be that court has relied on my weakness. Whatever my weakness, that is not the main thing. What they have proved and what they have adduced, that is the main thing, my lord. So this is a settled principle that plaintiff has to rely on his strength, my lord. He cannot rely on my weakness, my lord. And third one, my lord, if your lordship come to the decree of the appellate court. That is the page 39, my lord. Decree of the appellate court. Now, the instant appeal is allowed on contest without cost. Appellant plaintiffs have right, title, and interest in respect of 1/3 share of the suit length. They are entitled to get separate patta in respect of 1/3 share of the suit land after getting the land partition through concerned revenue authority. Now, giving patta, that is also not given power to the civil court, my lord. That is the exclusive power of deputy commissioner. And if your lordship will see 154, I've given that, my lord.
No, but deputy commissioner is now here, it's not, he is not authorized to give those, no.
My
Or
lord,
in the decree, it is silent, obviously, you rightly pointed out, it's silent that what may be, because patta, definitely you are saying, it is right submission that these things are under the deputy commissioner. He
Right.
will issue those patta and all, and this creation of patta, separate patta, these things are
Right.
under their
my lord.
domain. Okay, then, yes.
Then, my lord, that is also without jurisdiction, my lord. So I have formulated my questions of law
How
at
many?
page
1, 2, 3, 4, 5.
7, my lord. Yes. And my lord, the perversity covers everything, my lord.
Okay, we have identified some substantial question of law that will be reflected in our order.
Right.
And where is your I stand for?
I have for stay, my lord.
Very forward. নামটো কি বলবা কেন যেতে বলবে না গ্রুপ তেখেতক যিটো অৰ্ডাৰ তাতে আছে তেওঁলোকে তাতে চাবই পাৰিব যিজনে ব্যস্ত হৈ আছে পৰুৱা দি দিয়ক চৰি বৰ্মন দি দিয়ক আৰু ইয়াতে গোটেইখিনি okay it will be stated
My lord.
we'll pass the order substantial question will be formulated by us
Obliged, my lord.
মানে হেৰি আছে এটা
Obliged.
Sorry, my lord, I could not be present when the number was called for. The second time the bail application is being moved, my lord. And my lord, the order that has been passed by this court, there is a finding, there is some prima facie observation was made. What I have read it, and I found that in page 50. Nine, 90 days. 90. For 10 years, about 9 to 90 days. 90 days. This is 90 days, not 60 days. My learned friend is saying 60, I said it is 90 days, 90 days.
Up to 10.
Otherwise 60 days is complete, 63 days today. 60 days is up to, it's 90.
Because my lord, because my lord, yesterday I made submission, my lord. Mr. Watford is appearing in the matter, my lord. When I discussed with him, he just pointed out two things to me. Because in the schedule, my lord, that is, in the schedule, my lord, it is stated as the for 10 years, my lord. As per the schedule, if the, my lord, the sentencing period is for 10 years, my lord, so automatically it is, my lord, that is 90 days. But he again told me other that in the, my lord, that is the, my lord, that is in the act, my lord, in the provision, my lord, the word there is up to 10 years. But in the schedule, admittedly, my lord, senior submitted, I also gone through that, my lord. There, the word is there for 10 years. But in the, my lord, that is.
Up to 10 years.
Yes, my lord. There, my lord, up to 10 years. If it is, my lord, up to 10 years,
Maybe,
my lord. Then, my lord, as per, my lord, there is Rakesh file, my lord, then state. Yes, my lord, in the BLS, my lord.
Yeah.
Yes, my lord. My lord, but after, my lord, Rakesh Pal's order, there, my lord, then it is treated that if it is up to 10 years, my lord, then 60 days, my lord.
My lord, what I am saying with respect, my lord, this is no merit. What merit in a bail case? We knew, my lord, is a discretion of the court. Of course, it is based on a. No, he's right. Yes.
Because,
No,
my lord,
no, then automatically I should, yes, he's right. He's, yes.
because,
Yes. He is saying that up to 10 years. Up to.
my lord,
But-
that is in, my lord, in the, my lord, that is a provision of the section. But, my lord, in the schedule, my lord, that is word is used as a for 10.
40.
Yes, I know.
Yes,
My lord, yeah, in the schedule, my lord, it is for 10 years. But in the, my lord, that is, my lord, that is the provision where, my lord, that there, my lord, the word is up to 10 years, like 306 are there.
My Rakesh Pal also, that
Yes,
is
my-
that is observed.
My lord.
So, my lord, what I am saying, submitting, well, with great respect, only 63 days, my lord. And I cannot, my lord, what is there to argue? I have said I am a consultant. 37 projects, my lord, government projects, all I am handling. Whenever the investigating agency one, I'll cooperate definitely. There is no where I will go. He is not, my lord, he's an architect doing all government works. It is not normally, is all the government work, about 38 projects he is doing it. There is one difficulty. That is the difficulty that he is not being able to look into all this. And there is all time limit in all those projects, man. All time limit. Now there can be a termination. You don't do it. So he will face lot of difficulties. And already he is in custody, my lord. I don't want to reiterate and argue. All your lordship knows very well. And if the position of Rakesh Pal is also taken into account, it is already, if it is 60 days, even then, let us for an argument say 90 days. Let us for an argument say.
My lord, your lordship will kindly see the period of detention. And the suicide note already is with that WhatsApp. Now let's not go into the WhatsApp and forensic. Now it will not, how, my lord, I will temper. That's the only point. Temper, what temper? All it is on record, it has been seized. All has been seized. It has been seized. It is sent to FSL, it has been seized. What it comes, my lord, I have to face the trial. I have to face the trial. It has been seized by the FSL. If it is not seized, then of course, my lord. Your lordships, why custodial interrogation is required? Why it is required? To find a lead of it. Lead. But there are certain things that where by custodial interrogation may be required, may not be required. In this case, suicide note, entire suicide note will depend, and my only defense will be based on a suicide note where if trial goes, I have to face it. And the only is that he is an architect, my only is that he is an architect, 38 project, he will not leave. Whatever condition, stringent condition can be put by your lordship. And I will not repeat, your lordship knows the case, entire background of the case. And there is an interim protection which is given to a contractor. Kindly see by the learned Supreme Court, my lord. Protection, otherwise the Supreme Court has seen the FIR also, my lord. An interim bail was granted, an antecedent bail under 438, my lord. And these are persons who are already in custody, my lord. So there my humble submission, let him, my lord, your lordship will kindly consider, my lord. Kindly consider his case, and if your lordship looks into it, the learned PP also, if they say it is, but it is less than 63 days, 60 days, then already he has served. But if it is 90 days also, 90 days for an argument's sake, my lord, sufficient days, my lord. That's my humble side. I don't want to repeat the case, my lord. Your lordship knows, and there is a finding which has been certain including materials were found at that relevant stage. Your lordship found that no, we should not leave him at that relevant stage. Maybe. So that was the ground where your lordship rejected. Today is 63 days. Kindly consider, my lord.
My lord, because my lord, earlier occasion also I submitted, my lord. Mr. Lord, before my lord, he was supposed to appear, my lord. But before that, my lord, because my lord, the CD is available, my lord. That is the investigation agency, my lord, categorically filed, my lord. That is there is the objection prayer regarding the bail, and my lord, sufficient materials are there. Because earlier occasion, my lord was pleased to reject, my lord, the same. And my lord, may I read, because my lord, to make it clear, my lord, regarding the provision, my lord. Once again, my lord. My lord, on that point, if my lord, that is the position is that 60 years, then automatically, my lord, it is a case of default bail. My lord, 108, my lord, is abatement of suicide, my lord. If any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. My lord, here, my lord, that is the plain reading is, my lord, extended up to 10 years. Meaning thereby it may be, my lord, sentencing period may be below 10 years also, my lord. So then in that position, my lord, it is very clear it is 60 days. But my lord, it is in the schedule, my lord. In the schedule, my lord, it is in schedule, my lord, that is abatement of suicide. That is, my lord, that is a period is stated, my lord, that is the imprisonment for 10 years and the word is used as for 10 years and fine. If it is, my lord, for 10 years and fine, then my lord, that is the detention period is, my lord, up to, my lord, 90 days. That is, my lord, regarding that point.
Already, my lord, CD will reveal. The lordship has said that some intent materials kept him in the custody for further into investigation of the matter. But today, 63 has passed. What they will find, the same thing will happen. Same. That's a humble submission.
My lord, that is, yes, my lord, one, my lord, they have filed, my lord, that is the.
Represent to Isaac.
Represent to
Us. No.
Report.
completed.
FSL, my lord.
We are part here. Or in.
Report to ISM.
State of sending the exam, you did cannot be sorry, exam.
My,
Asking whether there is any report has been obtained by the IO from the level.
then my lord, matter may kindly be time being, my lord. So, my lord, Mr. Botto will come and my lord, just otherwise, or my lord, give me time, my lord, I will just my lord, go through that, my lord.
If up here, put the event that we call it.
Fine.
You will send.
Fine.
But it's, but report is still. Of the. That those were sent or.
FSL,
Examination, but.
my lord.
Finding. Like it's the both involved. It may take a role.
Right.
But still a bit.
My lord, that is a, that part is.
Peace and good. Lordship, please.
minor, up to minor, up to minor. And even in the minor,
He'll cooperate. I'm sorry, my lord. Your lordship has said that.
I think corporate is needed.
Yes, yes.
Yes.
Your lordship can add one more line and he will not leave without the jurisdiction.
Should be there.
Yes, that's fair. I'm deeply obliged, my lord. Also.
My lord, I have a smooth prayer, lordship. I may be allowed to, lordship, to go through the record of item number 27, lordship. Otherwise, if item number 27, I want to, lordship, go through the record, lordship, verify the record. Otherwise, it will be very difficult for argument, lordship, or in my part. 27, lordship. Lordship. Voluminous documents, lordship, in this case, lordship, that's why, lordship, sir, my lord, yes, 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 consider, that's on record. Okay, if you love. For convenience of this court, lordship, that's to point out that, okay, if your lordship is,
All the, but yeah, it's there is some required to be by
my,
it's put up and take that. You're the
lordship, my, and for respondent, claimant, 27. Lordship, no problem. Lordship. My
May I please, your lordships. My lord, the appellant was the plaintiff. You file this. Here, the appellant was the plaintiff. He filed a suit for challenging its sale deed, which is forged. The plaintiff suit was dismissed, and in appeal was affirmed. And against that judgment, my lord, the second appeal has been filed. My lord, plaintiff. Plaintiff suit was dismissed. Then in appeal was also dismissed. It is concurrent findings. Concurrent finding. Though it is a concurrent findings, my lord, to my understanding, there's substantial question of law involved. Page 6 for a moment, your lordship, kindly see what I have formulated. We have challenged the sale deed on the ground of forgery. Plaintiff's father was the executant, and the sale deed was executed in favor of the defendant number 1 and defendant number 2 and 3. They are my brother and brother's sons. Now, question is that, my lord, we challenge this, it as a force deed and not force deed, and whether it is permissible that defendant number 2 and 3 were the minor at that point of time, it is admitted. Now, under section 11 of the Contract Act, whether the sale deed is valid or not, that point, my lord, that is the question involved in this, my lord, appeal. Two and 3, they are minors. They are minors at, yes, section 11 of the Contract Act. That is invalid. That is my the first question I have formulated here. Well, minor at that point of time. It is admitted. Now, section 11 is violated. It cannot be. Yes, they can, but guardian should be appointed on behalf of that. That was not done. That is the case. Right. Provision, yeah, but that was not. That is the. And the other relation is a fiduciary relationship, father, son, and so burden lies upon them to prove that it is validly executed. It is section 11 of the transfer of property. These two questions, madam, I have raised in this case. I'm not seeking any stay, my lord, because they are plaintiff suit. On this 2 point, it is better admitted. My lord, section 111 of Evidence Act, because this relationship between the executant and the his plaintiff, fiduciary relationship, father and son. And here it is a father was ill at that point of time. It is admitted. So burden lies to them that on behalf of the vendee to prove that this sale deed was validly, my lord, executed in favor of them because the father was at that point of ill. So section 111 of Evidence Act will be applicable. Burden automatically shift to them. It was not. Another point also raised, my lord, the father was a literate person, but this it said that the thumb impression is there. So doubt created. Expert was, my lord, called for, but question is that expert report is not, my lord, in page 37, expert report is that all the thumb impressions are not identical. In some pages it is identical and some pages not. Page 37, there is finding of the expert. For
No, Alan, he died. Some I-card was brought to the court and it was compared with this LD. Those identical, some preparation identical have come on. That's in case 37, it reflects. Appellate course of. Yes, it starts from page 24. And if your losses may come to the page 38, where I have said is that they are minor. One document I have exhibited, exhibit 5. One guardianship certificate was sought for from the district court. So it reveals that that at that point of the different number 2 and 3 were minor. Minor. After which. Yeah, your lordship come. Up.
There is item 10, Your Lordship. At the when the matter was called, Your Lordship, I was on legs, Your Lordship, in court number 4. So can it be, Your Lordship, posted for fixed at 2, Your Lordship, in the mint? Then date may be given, Your Lordship. Date may be given, Your Lordship.
No, we cannot give you anything. Because the other side was ready, because it was a case of post transfer case.
Yes, Your Lordship.
Another side was there. Mr. Abbas was there. But we are not there, so order has already been passed. It will be immediately.
I'm just saying for date, Your
Immediately
Lordship.
after Puja vacation. Immediately after Puja vacation.
Deeply obliged.
Okay, hearing item number 12.
Yes, what instructions do we have?
No, my lord, it is item number 12, my lord.
12.
Time being matter, my lord,
Aha,
scarcity was
yes.
there, my lord.
Okay.
That matter.
Yes, what is the submission?
Lordship, here there was a love relation between the accused and the petitioner, your lordship, and it has been even admitted by the victim also.
Earlier it was rejected.
Yes, your lordship. This is the second time we have filed this bail application. It has been 103 days, your lordship. And today, the session case is also there for evidence.
Case is already charged sheeted.
Yes, your lordship, it has been solicited.
Then
If lordship may come to page 6, paragraph 9, 10, we have stated here that from the FIR, it is revealed that the victim, girl, is of major annum. Both the petitioner and victim develop love affair between their own consent. As such, the ingredients of section 69 of PNS appears to be absent in this case, and also the petitioner begs to state that there is no evidences found with regard to the alleged pregnancy, lordship. So section 89 also appears to be absent in this case. The medical report also is found to be normal, your lordship, the medical report.
I go to Hong Kong. Google carry listing right. Carry A24, tinta listing. Submit. But then this does not affect, and the medical report also does not support the case of executive. Yes, Mr. Charge has already been paid.
Yes, your lordship.
This, my lord, earlier, my lord, this prayer was rejected on 7/8/2025. That is annexed, my lord. My lord, when, my lord, that petition was, my lord, filed, my lord, prayer for bail petition, at that point of time, already searched submitted. So after, my lord, perusing the scan PCR, my lord was pleased to reject the same. My lord, this page 25 of the petition, only some part, my lord, of that, my lord, rejection order. This is the first para, my lord. My lord, at that time, our colleague, Mr. B. Sharma, appeared, my lord, submitted in this regard that there are sufficient incriminating materials against the present petitioner, and on the basis of which the charge sheet has already been filed against him. He particularly submitted that in the statement made by the victim recorded under 183 CRPC implicates the petitioner, and the intention of the petitioner to deceive the victim is also found in the statement made by her. Mr. Sharma further submitted that there is probability of hampering or tampering with the evidence of victim and other witnesses if the petitioner is released on the bail. Hearing the submission made by the learned counsel for both the sides and considering the materials available in the record and the case diary, it is seen that the allegation brought against the petitioner that with a false promise to marriage, he had physical relationship with the victim, and the victim had also brought incriminating materials against the present accused petitioner in her statement recorded under section 183. Probability of tampering with the evidence, especially the victim, cannot be denied at this stage. So, my lord, that was the order first by your lordship on 7/8/2025. Now, my lord, at that point of time, already, my lord, CS filed, my lord, CS dated 27/6/2025, my lord. And my lord, cognizance and committal was that is made on 10/7/2025, and my lord, search frame on 29/8/2025. And my lord, on 20, my lord, may kindly peruse the order, search framing order, my lord, of 29/8/2025. That is in the record, my lord. I have, my lord, flag marks that order, my lord. My lord, learned session judge, my lord. My lord, may I only peruse, my lord, the paragraphs, my lord, 10, my lord, that is a 6 to 10, 6 to 11, that order. My lord. I have already pragmat my order of the search pen and the one search pending, my lord. Para 6 to 10, para 6 to 10. After framing of search, my lord, regarding my lord, the case management point on the point of case management hearing, my lord, a calendar is well prepared, my lord. And as per that calendar, my lord, every date is provided, my lord. Same is sent to the officer in charge so that, my lord, their, my lord, presence may be, my lord, made, my lord. And in this regard, my lord, the Honorable Apex Courts, my lord, there is judgment, my lord, Shailendra Kumar versus State of Bihar, my lord. That is, my lord, very much followed, my lord, in this regard, my lord. The very well versed, my lord. Very, my lord, totally, thoroughly, my lord, that was given. And today is the first date, my lord, tomorrow is the first date of evidence, that is 25/9/25. So in this regard, my lord, from that point of view, because my lord, earlier rejection, my lord was pleased to reject on that part, my lord, 15, at least, my lord, maybe witness, my lord, that is tomorrow is pending, and there is no inordinate delay, my lord, in this part. That's my humble submission before your lordship, my lord.
And not tomorrow. Today was the date fixed. Do you
My
have
lord,
any instructions?
tomorrow, my lord, as per the order, my lord, this is 25/9, my lord.
Today is
In-
25/9.
Oh, my lord, today is
So do
25.
you have any instructions in that regard regarding the presence of the victim?
Lordship?
Regarding the presence of the victim, whether her evidence is recorded, whether she is available? Victim.
Yes, Lordship. I have no
You
instruction.
don't have any instruction. Yes, every calendar is prepared in.
My lord, that is well prepared. Even my lord, thereafter, my lord, another para, my lord, in 11, my lord, another 2 dates also provided, my lord, 11 and 12, my lord, apart from that. So that, my lord, that is the speedy trial, my lord. His rights may be, my lord, protected, my lord. And that, my lord, was sent to the OC concern to make the presence of the, my lord, witnesses available.
Lordship, the recording statement of the victim is there, your Lordship.
Today.
Yeah, it was on 7/6/2025 recording statement. 7/6/2025.
No, date was fixed today.
For today,
As per the calendar,
I have no instruction regarding.
Because, my lord, that is in the case record, my lord, that is, we have orders it, order available up to 8/9/2025. Otherwise, my lord, there is regarding that delay part, my lord, there is no inordinate delay. Otherwise, on the basis of merit, my lord was pleased to reject the order after filing of the search sheet, my lord, that is on 7/8/2025. The sufficient materials are there, my lord.
You are Ms. MS AM Hussain.
Yes,
Heard MS AM Hussain. AN Hussain appearing on behalf of Mrs. P. Gogoi, the learned counsel for the petition, and also her. Mr. K. Busher, the learned petitioner, VP, appearing on state. This is an application. The section so and so in connection with the scan copy of the DCA has already been received. Next, it is submitted by MS Hussain that the present petitioner is innocent, and innocent, and he has not committed any such offense as alleged in the. However, it is a fact that there was a love relationship between the petitioner and the victim, and if anything has happened between them, it was a consensual. It was consensual. Further, she submitted that case has already been charged, charge has already been framed, and it case is at the stage of. The petitioner is in custody since that 103 days, and from the materials in the FIR, it is seen that the case does not affect, the case of the petitioner does not affect the section 69 of BNSS. Further, she submitted that the medical report also does not support the case of the prosecution. She further submitted that the accused being a president of his address locality, he will regularly appear before the learned session judge as and when the date is fixed. Next paragraph. Mr. Bushra Learned petitioner PP submitted this regard that the earlier bail application for the present petitioner was rejected by this court on 7/8/2025, wherein after perusal of the case record and the after perusal of the case record and also find that the chances of tampering with the evidence cannot be denied. From the he further submitted from the scanned copy of the TCR, it reveals that the charge is framed on 29/8/2025, and thereafter the learned session judge also prepared a calendar for examination of witnesses as well as for hearing, etc., which is already reflected in the order dated
29/8/2020.
dated 29/8/2025. When the charge is framed against the present petitioner under section 64(2) small m oblique plus 69/89 of PNS. Mr. Busher accordingly submitted that as per the calendar, today is the date fixed for recording of the evidence of PW1 of the victim, and he further submitted that that there is no new or urgent ground in the petition, which was earlier rejected by this court, considering the probability of tampering with the evidence of witnesses, especially the victim. Next, hearing this submission made by learned counsel for courts, I have also prepared this scanned copy of the DCI and the order passed by the learned session judge dated 29/8/2025, framing the charge against the present petition. It revealed that the order has been passed considering the view and directions of Honorable Supreme Court in case of Sailendra Kumar versus State of Bihar and others, reported in 2002 1 SCC 655. And accordingly, the list of calendar is also furnished to the OC of the concerned police station so that the case may proceed and to which accordingly and to avoid unnecessary. Thus, from the order passed by the learned session judge as well as from the early rejection order, it is seen that there is no new or urgent ground in the case, and the earlier bail application was rejected only considering the fact that there may be probability of tampering with the evidence of the witnesses, especially the victim of the PW1. In view of this, I do not have any reason to pass order of bail, only considering the length of detention at this stage without recording the evidence of vital witnesses of the prosecution, especially the victim of the state. In view of this, the present petition stands dismissed. Your petition stands dismissed. Let the evidence of victim be recorded, then we'll see to it. One. Order plan. Yes, Talundar, what was the case?
In this case, there's some order for taking steps on response number 3 as well as furnishing the amended cost title. There is some lapse on our part, Lordship. Sometime may be allowed.
Names of 1 and 2.
Two has
are
been struck.
struck.
And so far 3 is
Amended
concerned,
cost title is to be filed.
we have to take steps and we have to file amended cost title.
Yes.
Sometime
And what
may be
about
granted.
the position of the other respondents? Have you taken steps for the other?
Only 3 respondents there.
Acha.
3 respondents, 1, 2 struck out. So far 3 is concerned, we have to take steps.
So now you have to file the amended cost title also and it to take
Take
steps.
steps on 3.
But Mr. M. Talbot, you done it counsel the applicant. Is submitted by Mr. Talbot he inadvertently the amended cost title, striking out the name of respondent number 1 and 2 would not be filed. And the same time, the steps in the respondent number 3 also would not be taken due to inadvertent mistake. But inadvertently leaks an alphabet. In view of this, the applicant is hereby directed to file the amended cost title, deleting the name of the respondent number 1 and 2, and also directed to take steps on the respondent for to register it in Pakistan. The list matter immediately after petition as of it. Earlier, it was a disposed matter.
No,
What
Lordship,
is disposed?
this is not disposed of matter. The delay confirmation application is there, that was disposed of. 4013. Oh, earlier it was disposed of matter, dismissed for default, for non-prosecution, and thereafter we have filed restoration petition along with delay condemnation petition. Delay condemnation petition allowed and
Restoration
restoration
pending.
remains.
Who's application?
Obliged.
Notice was issued earlier.
What office note says? Steps on respondent. The section did not receive the notice. Have you taken steps?
My lord. So far, my lord, instruction, my lord, we have taken steps, my lord. Let us, let me
may not
verify, my lord.
receive by the concerned section, I don't know, but as per office note dated 20/09/2000, it has not been received by the section. Till date.
My lord.
Till 29.
May I verify the records? My lord? And we may be permitted, if, my lord, if not taken, we may be permitted to test this. Nothing.
Air Signal Delan Council for the petitioner. As per the office note dated 20/09/2025. Concerned section has not received the notices on the respondent. However, it is submitted to Mr. Sector that as per his instruction, they have already received for the response. In view of this, the matter may be verified, and if matter may be verified and service be awaited for the respondent. However, in case the steps are not taken by the petitioner, it is it is directed to take steps immediately. I have already, you can verify. And if it is taken, then we will await this after petition. It's your experience is completed here. Service is completed here. You are appealing for 21?
Yes.
For the what appellant? Component.
Yes,
What is your good name?
Raman.
You are appealing on behalf of whom? You are appealing on behalf of whom?
Applicant.
No, any counsel. Your name is not here. That's why I'm asking.
P. Bharadwaj.
P. Bharadwaj. Acha, P. Bharadwaj. That is you are the appellant, na? That means you are for the appellant.
Lordship, pardon, Lordship, respondent, Lordship.
Over. Yeah, telephone. Now just tell us, I'll just verify for you. You may not be acquainted with the record and the procedure. I'm just asking you, you are appearing for Mr. P. Bharadwaj.
Yes.
So Mr. P. Bharadwaj's name is reflected in the column of this appellant. Plavan Bharadwaj is the P. Bharadwaj, isn't
Yes.
it? You have the appellant. It would be hearing I to filing number. I to it will I.
Appellant.
Repeat that. But did you got four parents have it? Right, just did. How do you got? Mr. Amrapan appearing on the paper, the appellant. For which the service is still awaited for the number 3. Post service be awaited till next date of listing. Listing matter accordingly immediately after. Okay, by listing it after vacation. After vacation, we are listing it and service for the respond number 3 will be awaited.
82.
May please, your lordship. Lordship, it's IA for early hearing, lordship.
I for early hearing.
Lordship. Appeal number 1 is suffering from various ailments, lordship. So he's praying for early hearing, lordship. The matter may be listed after the puja petition, lordship.
Lordship, after 15 November, I'm appearing on behalf of respondent number 1, D. Kalita. No.
My lord, I'm appealing for respondent, the state respondent 9, 10, 11.
9, 10 and 11.
9, 10, 11. And this is already a matter of 2015. So it is already due. So the state is completely supporting the early hearing petition. It may be heard early and completed.
Yes, lordship.
It is not proper such a case to go for such a long.
And you are for 1 and 2.
Respondent number 1.
Respondent number.
And one more thing, my lord may want to know, the orders below, both of them are concurrent.
The concurrent decision.
Yeah.
Go on, Mr.
M. Ahmed.
M. Ahmed. Mr. M. Ahmed, you can hire to learn counsel for the applicant. Also for MS, you are MS.
R. Core.
R. Core appearing on behalf of
D. Kalita.
appearing on behalf
D.
D.
Respondent.
Kalita for the respond number 1, and also for Mr. A.K. Parasaji, the learned government advocate appearing for the respond number 9, state respond number 9, 10, and 11. This is an application under section 151 CP praying for early hearing of the RSA connected RSA number 163 of 2015 is pending since long for it. The other side also raised no objection. Petition is according to this photo, and the connected RSA 163 of 2025 may be heard in the next date of listing.
Lordship, on 15th.
Parties are hereby directed to proceed with the hearing. Yes, what?
Lordship may fix the date, Lordship may give a date on 15th or 14th
15th or 14th of October.
October, Lordship.
Now we are
15, no, ma'am. After 15, no, ma'am.
after 15th
No, ma'am.
November.
On November, definitely.
Yes.
Month of October, I may not be available.
Next the puja is there, my lord,
Just
October.
Second part of November.
11th of November will do. Okay, we're fixing it in 11th of the.
Lordship may give
November
a
and we'll-
earlier date, Lordship, because his health condition is too bad, Lordship. The appellant's health condition, appellant number 1, Mohiruddin. So Lordship may give a earlier date, Lordship.
I will suggest if it can be, yes.
Lordship may give in the second, third week of October. 20 or 20 or 22, 23.
They're all holidays.
Fixed,
in
Lord.
fact, huh?
No, October lots of hearing that is fixed. Lordship. That's not possible.
In this court also, we have already fixed 16 is full. This is the Tuesday, I think, Thursday, I think.
My lord, 11 October is all right, my lord. What is the problem? They will get some time to prepare the case.
11
The
October, will go ahead.
No, 11, 14th,
14th of November.
no, October.
He is suggesting 14th
14th of
October. 14th
October.
October, we are full, I think, na? Good matter.
That will be exactly after
14th
opening the puja. That will not be.
Good, sir. 16 hearings have been fixed 14. It's not at all possible. 14, 16, we are full. 14, 16 of October, we are full. Then again, next week, 21st was the hearing day. That is also holiday. Then
Takes the
23rd, I cannot say.
First week of November. Lord. It will be
First.
first week of November.
Immediately, that is on 4th of November, we'll do. Otherwise, 4th of November. 4th of
It's all right.
4th of November করে দিও 4th of November মানে একটু ডিসপোজ হবো যেটা আরএসএ আছে আরএসএ আর্টফেন্স in view of order order passed in IS civil 2838 of 2025 both the parties are hereby asked to proceed with the hearing accordingly. Then the matter be listed on 4/11 October. I need to dispose. Yes,
Please, madam.
there, you know, yes, in the morning hours, in fact, Mr. Srivastava is saying that he is from outside, in Kolkata, I think.
Yes, madam.
So, not that matter may be hard because yes, yes, what do you want to submit?
I understand, my lord. Therefore, yesterday we had informed Mr. Borua regarding the difficulty. And there is another difficulty. The name of Mr. Bidideka is never shown on the Wakalatnama. Even on the last day it was submitted.
Mr. Bidideka is now engaged.
He is engaged, but his name is not shown in the Wakalatnama. I'm sorry, in the court list. His name is shown in the Wakalatnama, but his name is not shown in the court.
No, anyway, if Mr. Deka is ready, then we can hear the matter. That's all. If you
Very well, my lord. I'm just praying for an adjournment today so that both the parties may be heard together.
no, it will be hard to get a why won't keep
This
it
is
as
not
part hard?
possible. It will require 2 days at least.
The part hard will be again,
Yes,
it
yes.
will be create problem. Why I'm saying because suppose after vacation my bench will be not here. Maybe outside outlines bench. So again it will create problem.
My lord, in that case, I suppose.
Otherwise, you do one thing. We'll fix a date specifically at a date that you it will be a bit lengthy, I think, submission from both sides.
No, no, no. I'll
2
not
days,
take,
why you are saying 2 days? 2 days time?
no, no, because if they submit something, I'll be requiring another 5 minutes on my rejoinder. That is a remote. It may not be required at all.
No, no.
Once I finish,
Hmm.
they can make their submission and your ladyship may pass a final order. And I will not take more than 20 to 25 minutes
No,
at
no,
a
no,
stretch.
I'm not on that. If I suppose hear you today,
Yes.
and you are ready to for hearing today or not?
No,
That's what
my
I'm
lord, I'll pray for an adjournment today.
Then part third to not possible. Because of our problem is there that my roster may not be here after vacation. That is another problem. So it cannot be, it will be again delayed. That is why we want to hear both the parties together, in fact. So if a date can be given in the month of, I don't know, month of October may not be possible. Maybe on month. Maybe in the first week of November, either 3, 4, 5, 6, if it is possible.
Madam, with the
matter may be hard.
convenience of
In
my
that
learned
case,
friend, if a
you
date,
just think one thing. Inadvertently, there may not be reflection of the name was not
I
reflected in the cause date.
the date was fixed,
But
my lord.
if he is aware about the same, then definitely matter could have been heard.
Matter
in
could
fact.
have been taken. But if a date is fixed, I would only pray if a date is fixed after vacation. If in case the matter requires a lengthy hearing to the matter can be taken
No,
up.
no, he is not saying that lengthy hearing will be required. He is saying only 20, 25 or 30 minutes
Yes,
at
yes.
best,
Yes.
as part from his part. And your part, it may tweak, and then as usual, it will be listing. Then we can make a date, and it may be listed at 2 or 3. That specific time may be also mentioned.
That may be
In that
done, my
case,
lord.
it will help both the parties. That matter may be reached, and it will be heard at 2 p.m. That kind of order can also be passed. Otherwise, if you are ready, then I'm ready to hear.
My lord, I would pray for an adjournment today. If a date is fixed along with the time, I suppose my learned friend would not suffer inconvenience.
Yes, Mr. Shiv, what do you say?
I'll leave it to your ladyship because I mean, if they were not prepared or his senior was not there, I could have been informed. I could have taken some other matters at Kolkata rather than coming here. And both of them were talking, but I was not informed that his senior won't be there.
You are not. You were also talking with.
Yes,
Yesterday I was-
Yesterday
I could have cancelled my ticket instead of coming here.
yesterday evening time, his colleague called me.
Ah.
Well, already he's present in Guwahati.
I was already here.
Oh, he was already.
Already reached Guwahati.
So it may happen on any day.
Obviously, you have come from outside Assam, so that's
Correct.
why I thought that it can
So
be
even on
accommodate-
next day, it may happen. If his senior is not coming, then hearing will not take place despite a date being fixed. So this is going to continue.
No, that is
And
not the
and
case.
I
I'm only making
normally
a-
I don't seek a peremptory order that if he is not there, I should be heard.
Mr. B.D. Deka, I know him. It is the if it is fixed, then definitely he will try to go for the hearing. That is not the case. I know personally Mr. B.D. Deka is not so, but it will take time because I don't know why today, if it is he is ready, then we are ready to hear. Go ahead, because
Great.
we the code as a code, we want to accommodate you as you are from the outside Assam.
Really?
So that is the case. You just inform Mr. B.D. Deka, we'll ask the registry to reflect his name. Suppose in case, even if in case, then also let him prepare then.
I'll make it a point, my lord, next time he appears.
Because now see, there are some issues are there because in the morning hours only the mention was made for hearing. That's why we thought that leaving apart the other hearings and all, we'll take up this hearing. Mr. Borua was also there.
Yes, Lord.
Mr. A.K. Srivastava, the learned so for the petitioner and also part. You are Mr. Chaudhary, no?
And Chaudhary.
And Chaudhary. And Chaudhary appearing. And Chaudhary for the response. However, it is submitted by Mr. N. Chaudhary that they have already engaged Mr. B.D. Deka to for the hearing as his earliest engaged counsel, Mr. For the hearing. But as his name was not reflected in the cause list, Mr. Deka is not prepared with the for the hearing. Accordingly, Mr. Chaudhary did and adjourned. Did the matter be listed? Yes. Tell me. On which date?
6th of November.
6th of November at 2 p.m. We'll refund at 2 p.m. Let the matter be listed on 6th of November at 2 p.m. And the both the parties are hereby directed to proceed with the hearing without seeking further action. Okay.
You see,
So
one
we are
request,
listing it
but
on
that should not
6,
be part of the order.
11 at 2 p.m. Pardon?
That should not be part of the order of the record. They should at least inform my assisting advocate that they are not prepared. So I'll at least cancel my ticket and take care of my.
Because of the name matter that we had informed yesterday, but till then.
But yesterday, if you inform me in the evening, and my flight was at 4:10, I had no choice but to come. And the another flight was at 8:50, which becomes very.
I apologize for the inconvenience.
Okay, then we'll probably be, hopefully it may be heard on that.
Grateful.
Deeply. No, no, I'm getting to it. So getting to it. Really, the one that I think clear. Just two bail matters are there, will later it will become.
One item one, I think.
Yes, item one, this, and one more bail matter is there. Yes, what is the item one? What is the-
Yes, we have taken the instruction, my lord, from the OC concern, my lord, regarding whether such is filed or not, my lord. Then we have come to know, my lord, that is what my learned friend has stated that time. The CD is very much available in our, my lord, office.
Mr. Chaudhary,
Yeah.
are you Chaudhary? Who Chaudhary is that?
Yes, sir.
Chaudhary was that time.
Yes, that time he
So-
stated, so my lord, my lord,
Another
asked the
proposal.
office to bring the CD.
Another proposal.
Earlier, my lord, in the rejected, my lord has produced both the orders, my lord. My lord, in the same way, here also implications are there. Only 3 flags I have taken. His name is Lalsan Ali. His name is independent witness also taken. Otherwise, implications are there.
That is not disputed, my lord.
Yes,
Not disputed.
that. But my learned senior submission is there only the length of
4 days, my lord, today.
length of detention.
And your lordship was pleased to pass idea, my lord, 70, 92 days, 77 days, 70, page 35, my.
Yes.
So I am only on that, I am not on merit, my lord. Vacation is there also, my lord. So.
Full vacation is there, so.
So 84 days, my lord. I let your lordship, my lord. Already your lordship passed order, my lord.
Before vacation, चलो कुछ अच्छा काम करे.
Let him come, my lord. Let him observe also, my lord.
Okay. Yes, part Mr. H.I. Chaudhary, the learned senior advocate, assisted by Mr. Ayu Chaudhary. Counsel for the petition from Mr. K. Bush, the learned petition.
Petition of that is,
As it was available. Public. Right, it is submitted by Mr. Chaudhary, the learned senior advocate, that he is. His petitioner is innocent.
37.
Has not taken any such offer as the legality act. Further, he submitted that accused petitioner is in custody for 84 days, you are saying?
84 days.
84 days. 84
Today.
days.
Date of arrest is 3/7/25.
It's a different CGM and
Boy.
non-voting.
Hmm?
CGM 84 days in custody. Considering takes clear the possibility that there may be that. Further, it is submitted that a bill there for the other 3 co-accused persons were considered by this court in BA number 2624 of 2025, dated 17/9/2025, wherein also length of detention was considered and the bill was accordingly granted. Mr. Chaudhary, for the How many petitions are here?
One.
Only one. Na?
Huh? One to one.
Petitioner is a permanent resident who is address locality and happy with the learning platform. To learn it, and he will extend his cooperation as and when. Expect Mr. Bush to learn it. It's something. Coming to know about the availability of the essay. It has been paid and what it is submitted, there are sufficient informative metrics against present petition. However, on inquiry, it is found that the charges is not paid. Furnished by the I and the CD was also dying before the office of the board. However, he submitted that there are sufficient informative metrics against petition. But the fact that the case is still under the process phase. Considering the submission to impact without going into the considering the accused petition also considering the fact within 4 days when the filing the charges is also in view of this. Okay, will be
CGM নলবাৰী মানে
DJ null.
নলবাৰী obliged.
Oh, right. 15. Yes, Mr. Busso, 15 we have received. What we have received?
Yes,
Case diary or
we have
case
received the
record?
CD, my lord.
CD.
Yes, CD received, my lord.
Huh.
Earlier occasion, my lord, interim is there.
So what is your case, Mr. Chauhan?
My lord, while granting my lord interim, my lord, I was directed, my lord, to appear before the IU, my lord. I appear. Accordingly, my statements recorded, my lord. The case, my lord, registered under section 420, 468, 471, 408. In all the sections, my lord, punishment prescribes up to the 7 years. In such cases, my lord, under section 135(2)(3), my lord, of BNSS, my lord, that the police and my lord supposed to issue notice to the accused, my lord. And if my lord accused continue to cooperate, my lord, in such cases, my lord, arrest should not be made. This is the, my lord, provision
You
of.
didn't give the opportunity to IO to issue notice?
Yes, my lord, I am
You have
cooperating.
already
I am
obtained
cooperating,
the
my lord.
interim.
I am cooperating, my lord.
So now the question of issuing notice on 35 BNSS will not come here because you have already appeared before giving an opportunity to the police officer to issue notice to you. You appeared already.
Yes, ma'am.
And obtained the interim. Now let's
My lord,
focus about it.
if
And
my
what
lord-
is your case now? You have appeared.
My lord, if my lord, the petitioner to be arrested, my lord, then my lord, a reasonable order would be there. That why, my lord, it is necessary.
We are not
to-
on that now because that part is gone. That part is already gone. We have availed the opportunity of getting or procuring an interim order. So
Yes.
now the question of issuing notice and all is not there. Now your case is what? You have cooperated with the IO?
Yes,
You have appeared.
my lord.
And what?
I appeared
rest about
twice,
what-
my lord, but first time my statement was not recorded, but second time my statement recorded.
Statement is recorded.
Yes.
And that apart, what is your case? How you are
My lord,
involved?
I don't know, my lord, in the CD.
No. As per you are innocent.
My lord,
you are
yes, I
implicated.
appear, my lord, I appear. And my lord, my name is not the FIR, but whatever there in the city, it is up to the my lord PP. What is there, I don't know.
No. I am asking what is your case?
My lord, my case, my lord, that my lord, my name is not the in the FIR, my lord. Only my lord, police searching for perhaps to inquire me from to know me that some document, my lord, got by some other persons, my lord. In that case, if any role is there, that is the police wanted to know. That is the case all along, my lord. against me. And in this case, my lord, so by my instruction, my lord, 2 persons already long back were arrested and they were granted bail. My lord, kindly see page 16, my lord, Annexure 2, that is equity forwarding report, my lord, page 16.
First interim order was dated. First interim order was passed on when?
My lord, interim is 5/6/25.
5/6/25, yes. My
Interim-
first interim order on 23 January 2025. Conditions also imposed, my lord. So, my lord, my humble prayer, my lord, but this interim prayer, my lord, prayer may be absolute, my lord. If
At the time of
anything, my
granting
lord,
interim,
My lord,
there was an observation that he already appeared in,
my lord,
as per the submission made by Mr. Chong.
my
Or, oh, sorry, that time it was Mr. Majumdar was there.
my
That he already appeared before the IU in the month of July 2024, and his statement was also recorded.
Right.
And that statement was there. And but it doesn't contain even the CD we perused because the statement was not available.
my
But considering the fact that he had already appeared and cooperated in the investigation, the interim was actually done.
my.
So now what is the case? And
My lord, actually, this is a case of 2023.
23.
23. The affair is lost in the year 2023 by one my lord SI from Bokolial PS. This is regarding my lord. This is the case relating to my lord using the fake domicile of the state of Assam for the various my lord post of CRPF, my lord that is BSF, ITBP, SSB in many other, where my lord fake PRCs are used from the district of my lord Karbi Anglong by using so that they can get that they can avail the benefit for the northeastern people that is reserved category in those my lord cadres. By this way, different way, some people's name were entered in the voter list, same way fake PRCs were made, my lord. During the course of investigation at present, though admittedly, my lord, he is not a FIR name accused, but it is a racket, my lord, the big syndicate, my lord. Still, my lord, from 2023 to 25, my lord, police investigating the matter and finding the clue of one from another. Scattered way, many people are, my lord, associated. Now, present accused petitioner, my lord, during the course of investigation, from one accused person, co-accused, his name came out. So he is also one of the person who is an inhabitant, my lord, resident of that particular place, my lord. And within he is, my lord, also helping other people. They're very, my lord, they're very different kind of nexus. Some people are in the post office. Somebody is making the name in the domicile. One person has, my lord, bought a land in that particular area. Thereafter, by using that title, somebody first entered his name or her name in the my lord voter list. Thereafter, my lord, some PRCs were made. In the same way, my lord, even from the post office, people are there who, after taking all this thing, send it to the Uttar Pradesh and other places, my lord. Like this way, this nexus is coming out. From the one of the accused person's statement, the present person's involvement came out. Then thereafter, police make investigation. During the course, my lord, the BLO, who is for the my lord voter list, my lord, from his statement also these things has come out. And from the my lord, the statement of the my lord, what my lord, that is the village head. These are the independent witnesses, my lord, not only the confessional statement. And these things have come out, my lord. Otherwise, in this case, Master, it's a very serious offense, my lord. Maybe of 7 years, my lord. And his statements recorded. Even, my lord, one of his allegation to, my lord, include one of his nephew to one of this, my lord, paramilitary cadre is also there, my.
So this
This-
person is now, he is an employee in.
No,
in
he
any
is not
firm?
an employee. He is a my lord cultivator, as per our statement, my lord. He is a cultivator, but his my lord land is there, my lord. Now using that his land, my lord. Others people are, my lord, giving that opportunity of that is making or himself, my lord, in a forced way that he is the availability of domicile, my lord, for this area, my lord. So these were not only this
Karbi Anglong or?
Karbi Anglong, my lord. Karbi Anglong. So this is the case, my lord. Some, my lord, only horizontal flag marks are there for the relevant part, implicating this petition. That is before your lords.
My lord, my submission is, assume my lord, whatever my lord has said is correct, my lord. If the charge sheet, my lord, be submitted, and if,
Submitted.
Not my lord.
if my lord submitted, if his name be by in the charge sheet, my lord, certainly will face the trial, my lord. But it is,
Then do you have to? Then? So basically you are from Karbi Anglong, no?
no, I am from Kalibal.
Here?
I am from Karbi Anglong, my lord, and this petitioner is, my lord, a cultivator. Suppose, my lord, as stated, my lord, if my land is there, my land document obtaining by nowadays, my lord, from internet it can be obtained. If somebody obtained, my lord, and somebody use, my lord, to getting some document, my lord, how I am involved, my lord, I have not obtained any certificate or such, my lord, document in my name, and I have not used anywhere such a document. I am not beneficiary of such a document.
Okay, I'll produce the case diary and then only part two.
Bye.
Just I wanted to tell you one thing. I'll be able to hear up to 3:30 only. Because thereafter I have some long pending with these two, within these 2 days, we have wind up all the work and all.
Yeah.
So up to 3:30 only, if it remain part heard, then it will be, most probably it will remain as a part heard. In that case, it will be listed in the month of November, first week of month. Because October, we don't have any dates.
Lovely.
That's why. Or what do you suggest? It should
I will-
be
I will-
remain as a part heard or?
I will try within a very short period to complete. Because, my lord, this is a case.
No, I'm just hearing you.
Yes,
Yes, I'm saying it whether it.
No,
it want-
in that case, Lordship, on 25/9/2025, my learned friend has already argued, and
Where?
another
Before?
before Honorable Justice Ravin Pukan sir, but another substantial question of law was formulated on that day. So today, if I give first reply to that substantial question of law, then your Lordship, he can give his reply, or if he takes only 15 minutes, then I will take 15 minutes. Within half an hour, we can conclude, Lordship.
Oh, no, but the question is that matter was Matter was earlier heard by Justice Pupam.
It is not a part-heard matter.
No,
and
not a
it's-
part-heard matter. That's
Lordship.
what I'm saying. We have to hear because I don't know what was the earlier substantial question of
Lordship.
during the deliberation. Most probably it has come out that one more substantial question is required, and accordingly it was formulated.
Already he has
only
formulated
subsequent from this.
that's 25-9,
Ah.
Lordship.
But 25-9. But the question is that we have to hear the matter. Otherwise, we are not in a position to say anything. There may be substantial question of whether it is developed or not. That is different thing because as it is fixed in the for the hearing column, so we have to hear.
Yes.
So you just submit. I'll up to 3:30. I'll
Yes,
hear.
oblige,
Then if
oblige.
it is remain part heard,
Oblige.
it may be listed
Oblige.
in the month of November.
Oblige.
But it was not part heard before Justice Pupam.
No,
Not part.
only another substantial question of law was
it is there.
formulated. Lordship, if it takes half an hour, then I will take half an hour. It can be concluded itself, Lordship.
I cannot say.
Right.
Yes.
Oblige.
Right. So you have earlier submitted that you were the defendants
We are the plaintiffs, Lord.
and you were the plaintiff. So concurrent findings were there.
Yes.
And there are prayer portion I have already seen. One was your prayer. And the was submitted that the sale deed was executed in favor of the defendant by the landlord, as per you.
Yes, yes.
And the only document on the basis of which the decree was passed is the Khatian.
Khatian
That
exhibit
much
one,
you have
yes. Ma'am. So my next, I will draw your lordship to the substantial question of law framed by this honorable court. Order date 22/2017, 20 February, 20th February, 20th February,
20th February.
2017.
I guess. There are two substantial questions earlier.
Two, my lord.
Ah.
One is, my lord, whether the findings of both the courts below that the registered sale deed Exhibit 5 and Exhibit A was null and void is correct after holding that the respondent plaintiff be a tenant under the Assam Temporarily Settled Areas Tenancy Act. And number two was any other substantial question of law. And under these two, on 14/8/25, your lord, see the order 14/8/25. The second substantial question of law was
Yes, it was framed. sir.
yes, framed. So, my lord, the first substantial question of law regarding the tenancy, that is both the court held that plaintiff is a tenant. So the question was formulated that this finding whether affects the sale deed of the defendant, whether the
Otherwise,
finding
the
of
concurrent
tenant,
finding is that the plaintiff was a tenant.
my lord. And based on that he is a tenant, so my sale deed is cancelled. That is being an existing tenant under the 71 Act. The otherwise it may be interpreted as landlord cannot sell, my lord. So, my lord, on the first substantial question of law, I will submit, or my lord, in the second substantial question of law was, my lord, whether the judgment of the learned trial court as well as the first appellate court suffers from perversity on account of non-consideration of evidence of DW 1, 2, 3, 4 in deciding the issue at the point of determination formulated at the time of hearing. So, my lord, if your lordship permit, I will first submit on the second substantial question of law. And my lord, there were that may be noted, my lord. Three witnesses were adduced by plaintiff. PW 1, 2, and 3 is important. Plaintiff adduced the evidence of himself and two others. And exhibited 7 documents, exhibits, my lord, the plaintiff. Defendant adduced 4 witnesses, my lord. That is also important, my lord. DW1 is himself. DW2 was the staff of the sub-register office to prove the sale deed. DW3 was one of the witness of the attesting witness of the sale deed. DW4 was one of the witnesses, and as per evidence, he is one of the cousin brother of the defendant. And that oral evidence was very much important regarding one of the prayer was that confirmation of possession, whether the plaintiff had the possession or not. Without examining or without the appreciation of the evidence of the witnesses, it cannot be concluded, come to conclude that the possession is of the plaintiff. And since Exhibit 1 is a khotian, the based on which, Your Lordship, both the courts decreed the suit in favor of the plaintiff. And khotian is other words is the jamabandi, that is record of rights. So it is a settled position of law that khotian or records of right neither creates nor extinguish the title. It is a principle of law.
Yes.
So based, and khotian is prepared, it is another principle of law that khotian is prepared. Khotian can prove the possession, not the title. And khotian is, or record of right is prepared on the basis of actual possession of physical possession. So my submission in that regard is that since not a single witness, either of the PW's plaintiff's witness, nor the defendant's witness is appreciated in the by both the courts below. So may I bring Your Lordship's attention to the judgment of the trial court first, Your Lordship, page number 30. Whether the witnesses were, evidence of the witnesses were appreciated or not. Page number 30, the judgment of the trial court. So based on the pleadings, Your Lordship will find the issues, page number 34, Your Lordship. Page number 34, the issue number 1 was regarding cause of action, Your Lordship. And issue number 2 was maintainability. Issue number 3 is barred limitation. 4, 5, and 6 are the main issues. 4 is whether plaintiffs have tenancy right in the suit. That is whether he is a tenant. And whether the registered Kobola so-and-so is illegal and void. That is my sale deed. And number 3, whether entitled for any relief as prayed for. So there is no issue formulated regarding the possession. Though one of the prayer was that for confirmation of possession. So it is mentioned in the, my lord, next to the issues that the plaintiff side adduced 3 witnesses. And 27 numbers of documents. The witnesses were cross-examined by the defendants and discharged. On closure of the plaintiff witnesses, the defendant side was given opportunity to adduce their witnesses. The defendant side also adduced 4 witnesses and 2 numbers of documents. I have heard the argument advanced by the learned counsel, both the sides. So the 3 PWs and 4 EWs were examined. Now, Your Lordship, I will skip the issue number 1, 2, and 3 regarding cause of action maintained with this. So may I come to the page number 36, the main issue, issue number 4. Issue number 4 was whether plaintiff has a tenancy right. May I read well this issue? This issue relates to right of the plaintiff as tenant over the suit land, and therefore burden lies upon the shoulder of the plaintiff to prove this issue, the plaintiff side adduced 3 witnesses and 7 numbers of documents. The plaintiff is examined as PW1 and in support of claim submitted evidence on affidavit as for oral evidence. He submitted that he took tenancy settlement of the suit land and other land from Rakesh Chandra Das. Rakesh Chandra Das is the father of my vendor, my lord. And Rabindra Chandra Das is the brother of Rakesh Chandra Das. 1368, and in the same year, the Pattadar recognized his tenancy settlement of the entire land. He had purchased and issued the final khatiyan number so and so, granting rent received dated so and so. He submitted the, so in this point, my lord, these 2 documents is Exhibit 1 and Exhibit 2. Exhibit 2 is the land receipt. So, my lord, without going to the evidence, in the evidence of the PW1, your lordship, he has categorically admitted that his landlord, Rakesh Chandra, expired in the year 1973. It is admitted in the evidence. And the rent receipt he had used is Exhibit 2. It is mentioned date is 77. Rent receipt is 77, and he admitted that the landlord expired in 73. And both the court below did not appreciate the oral evidence of the witnesses. He submitted the original final khatiyan, which is proved as Exhibit 1, and also submitted the original rent receipt dated 27/12/77 BS, which is proved Exhibit 2, and Exhibit 2 was issued by the Pattadar who signed therein in presence. He proved the signature of the Pattadar of late Rakesh Das by 2-1. The plaintiff PW1 also submitted that the Exhibit 1 was finally published in 1975 with the knowledge of all the concerned, including the defendant, and he is in the possession of the suit land along with other land. On perusal of both the documents, it is found that Exhibit 1 is the final khatiyan issued in the name of plaintiff as tenant by Pattadar Rabindra Chandra Das. So the final and 5 others, it is important, my lord. This khatiyan is Exhibit 1, based on which both the court declared the suit. It is mentioned that this khatiyan is issued by Rabindra Chandra and 5 others. These 5 others, including my vendors, also my lord. That is, my vendor is also one of the Pattadar of this khatiyan. So the plaintiff cannot deny that my vendor had no right, title, or interest over the suit land. The suit land bearing DAG number 1097, measuring about 1 biga 14 kata and 4 sotak is found included in the said khatiyan. On perusal of Exhibit 2, it is seen that said Exhibit 2 is also the original receipt being issued by Pattadar Sri Rakesh Das, issued so and so. So your lordship will find, on going to the evidence, oral evidence, that there are discrepancies in this Exhibit 2, the rent receipt. The rent receipt is a supporting evidence of the khatiyan, because only by adducing the khatiyan without supporting the payment of the rent cannot be a document for title. On the other hand, to deny the case of the plaintiff, the defendant in their evidence submitted that the suit land is exclusively belong to the father of the defendant number 4. Defendant 4 is my vendor. By way of periodic Khiraj Patta number so and so, Banyargul Mauza, and after the death of his father, he became the owner of the suit land. The defendant Amoresh Chandra Das also denied that late Rabindra Chandra was the Pattadar at the said suit, but name of the plaintiff was wrongly recorded, Exhibit 1. On bare perusal Exhibit 1, seen that the Rabindra Das was entered into the said final khatiyan as Pattadar along with 5 others. So the khatiyan itself is evident that along with Rabindra, the alleged landlord of the plaintiff, other 5 persons are there, 5 others. Hence, the contention raised by the defendant number D1 to the fact that Rabindra Das was not the Pattadar of khatiyan cannot be accepted. In regard of wrong entry,
of the name of the plaintiff exhibit 1, Khatian so and so, no cogent evidence has been cited by the defendant side. However, the defendant side filed Xerox copy of periodic Kiraspatta number so and so issued in favor of his father, late Rakesh Chandra Das, and some other rent receipts issued by the Rakesh Chandra, but has not been examined the original. Being the Xerox copy, these documents carried no evidentiary value at all. So, my lord, on the failure on the part of the defendant to prove his title, the plaintiff's suit cannot be decreed. This is a settled position of law under section, my lord, 101 of the Evidence Act. That is, the plaintiff have to prove his case. The plaintiff cannot rely on the weakness of the defendant. Defendant could not prove, that cannot help the plaintiff to declare his title over the suit. This is a federal position of law. Though the defendant did not adduce the original copy, did not produce, but it is the burden on the plaintiff to prove his case. Mere Xerox copy, these documents carried no evidentiary value at all. If we carefully and comparatively scrutinize these documents, then it appears that the documents submitted by the plaintiff side are original documents, and the documents submitted by the defendant side is mere Xerox copy. As such, the documents of the plaintiff have a high evidentiary value with respect to the documents submitted by the defendant. I also perused the schedule or boundary submitted by the defendant in case of denial of the schedule and boundary of plaintiff, and found that both the schedule and the boundary are same without having contradiction. In view of the above discussion and reasoning, it appears that the plaintiff was a tenant under the Pattadar, late Rabindra Chandra Das, and other land. His name was rightly included in the final Khatian. Accordingly, the issue of decided in favor of the plaintiff and the defendant. So none of the, my lord, the witnesses was mentioned. Out of the 7 witnesses, 3 PWs and 4 DW. Next issue, my lord, regarding the sale deed, issue number 5. This issue relates to whether the Kobola deed number so and so, dated so and so, executed by Bimolendu Das. Bimolendu Das is defendant number 4, my lord, my vendor, in favor of defendant number 1, Sri Omaresh Das Belidor Boyd. To establish this issue in favor, the plaintiff submitted the Exhibit 1, Exhibit 2, and Exhibit 5. In regard to Exhibit 1 and Exhibit 2, it has already been discussed in issue number 4 and accordingly decided in favor of the plaintiff. Exhibit 5 is the alleged sale deed of 3042 executed by the defendant number 4 in favor of the defendant number 1 on 2706, which is challenged by the plaintiff. On bare perusal of the alleged deed, it is seen that the defendant number 4, Bimolendu Das, sold out the suit land to the defendant number 1, Omaresh Das, claiming his right inheritance from his father, late Rakesh Das. But his right of inheritance is challenged by the plaintiff, submitting that he is the tenant of the said suit land, which said had been settled by the predecessor of the defendant number 4. To prove his tenancy under such Pattadar, he has submitted Exhibit 1 and Exhibit 2, which is found correct and authentic. This is a perverse finding, Your Lordship, because if it is not discussed the oral evidence, the oral evidence, it is clear that there are many discrepancies in this document. Manipulation in the document. Here it is held that found correct and authentic. And that document was under objection. That document also under objection at the time of exhibition. So the trial court held it is authentic, but the defendant could not submit any documentary evidence except some Xerox paper in respect of his right of inheritance. The defendant appellant pleaded that he is one of the tenants. It is one aspect. Another aspect, he is the purchaser of the land from his landlord. So though it is held that by adducing the Xerox copies of the Khotian, he could not prove his inheritance. The defendant side could not show any evidence to the fact that the father from whom he claims his right of inheritance was the exclusive owner of the suit land. From the pleadings documents submitted by the so my lord, the exhibit 1 itself proves that the Rakesh Chandra was the father of my vendor.
So, but in one hand, you are claiming that right of purchase you are claiming, na?
Yes.
So, but to prove that you could not produce any kind of document. But repeatedly it is saying, it is discussed.
Regarding my tenancy, my lord. Regarding my tenancy, it is held that I have not adduced any original document, Xerox copy. Tenant, my claim was that I had pleaded that I was also a tenant under Rakesh Chandra. And but original document is not adduced. That is a Xerox copy he has submitted, my defendant submitted. Xerox copy of his Khotian. Plaintiff submitted original Khotian and defendant submitted Xerox copy of Khotian. So the defendant could not prove by adducing original that he is one of the tenant. He also one of the tenant. That is admitted. That he did not adduce the original Khotian. He adduced the Xerox. And regarding inheritance, my lord, it is the vendor of the defendant, my lord. Vendor of the defendant is the son of the original landlord, the mirasdar. And that is proved, here it is mentioned that my vendor could not prove his inheritance from the landlord. But the exhibit 1 of the, my lord, plaintiff itself proved that Rakesh Chandra is one of the pattadar. Out of 5 pattadars, I have already read, my lord, that Khotian exhibit 1, my lord, contains the name of 5 pattadars. One of the pattadars, the plaintiff claims Rabindra Chandra is his landlord, and other pattadars, I will show your lordship, that included the Rakesh Chandra also. And it is admitted fact that my vendor, defendant number 4, is the son of Rakesh Chandra. It is admitted by the plaintiff. It is not denied by the plaintiff that my vendor is not the son of Rakesh Chandra. And Rakesh Chandra was also one of the pattadar in the Khotian, exhibit 1.
You are claiming that your vendor's father was one of the
one of the landlord, one of the pattadar. It is admitted fact. From the pleadings, documents submitted by the either party and the oral evidence. So, my lord, no oral evidence is discussed. Out of the 7 witnesses, my lord, nowhere is mentioned what is stated by the witnesses, my lord. Though it is mentioned that from the pleading documents submitted by either of the party and the oral evidence, it appeared that the plaintiff was recognized as a tenant and his name was entered into the final Khotian on the basis of such tenancy right. And since then, he has been in possession. So, my lord, regarding possession, my lord, none of the witnesses' statement is discussed. The possession is only can be proved by the witnesses. None of the witnesses mentioned what they have said regarding the possession of the land. So the learned trial court held that possession, since he has been in possession of the suit land prior to the registration of the alleged deed, so and so, since the suit land had already been settled upon the plaintiff and his right was not terminated by any provision of law, his right cannot be interfered by way of selling the suit land by anybody else. As such, it can be held that the defendant number 4 sold out the suit land by so and so without having any right title over it. Accordingly, this issue is also decided in favor of the plaintiff. So the learned trial court held that my vendor had no right title in that. But how? The exhibit, if it is held a title document, the exhibit 1, for the sake of the argument, if it is held that the Khotian is a title document, but in that document, where the plaintiff's case is based. In that Kotian itself, my vendor's father's name is there. But it is held that my vendor has no title. So these are the two issues. And though no issue is formal, page number 39. Page number 39 is the issue number 6. Consequential relief. Plaintiff is tenant having tenancy right over the suit land as described in the schedule. So plaintiff is held as a tenant without appreciation of evidence of any of the witnesses. Possession of the plaintiffs over the suit land is described in the schedule of the land confirmed. Possession is also
Unlike criminal cases,
Yes.
in civil cases, do you think that oral evidence of every PW should be discussed there?
Yes, ma'am.
Because based on documentary evidence, I think. So that may be one of the aspects why
Yes,
it is
yes.
not discussed in detail regarding the
Yes.
the evidences of PW.
Yes. No mention is also there. No mention of the regarding the statement either in chief or no mention. And this honorable court being satisfied on this, my lord, the formulated this issue on the last occasion. So defendants are restrained, not interfere with the peaceful, and the alleged sale deed is set aside. Now, your lordship, I will come to the appellate court judgment regarding the appreciation of the evidences of the witnesses. Page number 9, your lordship.
Page number 9. Page number
It starts from 9, my lord.
9.
9 appellate court judgment.
Yes.
Page number 15, my lord, the issues, the mentioning the issues, the learned appellate court formulated 2 points for decision. Below of the page, my lord. Number 1, whether the plaintiff took tenancy settlement of the suit land from his original owner in the year 1368 BS, and whether the sale deed number so and so executed by the defendant number 4 and defendant 1 in respect of the suit is valid. So the appellate court also did not frame any issue regarding the possession. Though it is an important issue, whether he has the possession or not. And without issuing any, without formatting any issue, the trial court has held that the plaintiff has the possession without discussing it. So the page number 16, my point number 1, plaintiff, in order to substantiate his claim that he took tenancy settlement of the suit measuring 1 biga 14 kata 4 sotak covered by dag number so and so, exhibited final Kotian number so and so. I have perused the aforesaid final Kotian, and on perusal of aforesaid Kotian, it indeed appears that the suit land covered by dag number so and so is settled with the plaintiff along with other land covered by different dag measuring several bigas of land by his original owner, including Rakesh Chandra Das. Rakesh Chandra Das is my vendor's father. So it is admitted. And Rabindra Chandra Das is claimed by the plaintiff. Now, if we draw the attention of section 58(5) of the Assam Temporary Settled Tenancy Act, we will find that it categorically stated that every entry in record of rights finally published shall be conclusive evidence of the matter referred to in such entry and shall be presumed to be correct until it is proved by the evidence to be incorrect. Further, the Honorable Guwahati High Court also in case of so and so states that every entry in the record of rights finally published shall be conclusive evidence of the matter referred to in such entry and shall be presumed to be correct unless it is proved by evidence to be incorrect. The burden of proof that such entry incorrect shall be on the person so ascertained. Now that being position of law, I am of the considered opinion that the burden of proving that the final Khatiyan is incorrect rests upon the defendant when the statutory presumption is in favor of the plaintiff as per Exhibit 1 document. And we know that a presumption makes a prima facie case for a party in whose favor exists. Now let us see whether defendant has discharged his liability. To find out the answer, let us peruse the WS of the defendant at the outset. The perusal of WS submitted by the defendant 1 to 4 reveals that defendant number 1 to 4 in para 8 of the WS also admitted the fact that the name of plaintiff is recorded in final Khatiyan number 468 against the suit land. Nowhere they took plea that it was recorded wrongly in final Khatiyan and same was issued collusively by defendant number 5 to 7. But if we peruse the entire materials available on record, we will find that there is no iota of evidence, be it oral or documents. So your lordship will find there is no mention of any of the witnesses, my lord, but this appellate court also held that by evidence, oral and documentary evidence substantiate their claim that the name of the plaintiff is wrongly recorded in respect of suit land in Exhibit 1 document, nor plaintiff was able to brought on record as to why defendant number 1 to 7 will illegally enter the name of the plaintiff in revenue record of right in respect of suit land. Now, in the instant case, Exhibit 1 document makes out a case and there is a statutory presumption as per Section 58(5) of the Assam Temporary Settled Areas Tenancy Act in favor of the plaintiff. So the defendant is duty bound to prove the collusion and set forth the ground on the strength of which he claimed that final Khatiyan was wrongly recorded, but in the instant case, the materials available on record disclose that defendant miserably failed to discharge his liability. So under such circumstances, I am of the considered opinion that presumption of law existing in favor of the plaintiff on the strength of Exhibit 1 remain unrebutted. And on that count, I am of the considered opinion that no option is left to the court, but is bound to take that entry made in final Khatiyan Exhibit 1 as correct and proved. More so when the mandate of law laid down under Section 4 of the Evidence Act categorically states that whenever it is directly directed by the Act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So, in the backdrop of above discussion, I am constrained to decide this point in affirmative and in favor of the respondent plaintiff. Point number 2, as regard this point, let us first draw attention of Section 7 of the Transfer of Property Act, which deals with the person competent to transfer. The aforesaid section reveals that in order to dispose of transferable property, the transferor must be competent to contract and have title to the property or authority to transfer it is not his own. So the second point, my lord, that to be proved that my vendor has no title. Now in the instant case, as we have found in the discussion made in point number 1, that the tenancy settlement in respect of suit land is already been made in the year 1368 by the predecessor of defendant number 4 in favor of plaintiff. So I am of the considered opinion that defendant number 4 had no title over the property as mandated by Section 7 of Transfer of Property Act to transfer the suit. So that is predecessor of defendant number 4 means the brother of the predecessor of defendant number 4. That is the Rabindra Chandra Das was the brother of my lord the Rakesh Chandra Das. So though it is held that the brother of the Rakesh Chandra Das, Rabindra Chandra Das, had issued the Khatian, then nowhere it is mentioned that the title of the Rakesh Chandra Das exhausted. It is not mentioned, my lord. Though it is mentioned that predecessor of the defendant number 4 had issued the Khatian, but it is not mentioned that the one of the Pattadar, that is Rakesh Chandra Das, vendor of father, has exhausted his title. It is not there. The property as mandated in section 7 of the Act to transfer the suit land. Again, in favor of defendant number 1, the defendant number 4 being a person not competent to transfer. So it is held that my vendor has no title. Not title. Cannot transfer the suit land in favor of the defendant number 1. So though it is admitted that my vendor's father is one of the Pattadar, in the exhibit
This
1,
name reflects in the Khatian.
in the Khatian, my lord. And one of the Pattadar is this Rabindra Chandra in the Khatian. And the Honorable, both the courts held that no title, I have no title. If it was only Rabindra Chandra Das in the Khatian, then there would be a case for that. The Pattadar is only one Pattadar, Rabindra Chandra, and my vendor's father's name is not there. So no title you cannot say. But my father, my vendor's father is one of the Pattadar. The defendant number 4 being a person not competent to transfer, cannot transfer. So I am of the considered opinion that the document number so and so executed by defendant number 4 in favor of defendant 1 is void document and inoperative in the eye of law. Further, if we draw our attention to the recital of prime document of defendant number 1, exhibit A. Exhibit A is my sale deed. We will find that it does not tell you the aberrament made in para 8 of WS. Exhibit A reveals that defendant number 4 claim right title, interest, and possession over the suit land after the death of his father, and he, in order to meet his urgent need of money, sold the suit land and handed over possession of the suit land to the defendant number 1 on the date of execution of the sale deed number so and so. But the case of the defendant in para number 8 is somewhat different. Para number 8 reveals that defendant number 1 is an occupancy tenant of late Rakesh Chandra Das, father of defendant number 4, in respect of the suit land. And since his lifetime, defendant number 1 is continuously possessing the suit land. So, in this regard, my submission is that the pleaded case of the defendant 1 is he was a tenant, like the plaintiff of Rakesh Chandra Das. So, if a tenant that he is in possession. So, at the time of execution, the sale deed, exhibit A, my vendor mentioned that he has handed over the possession. And so, this is reflected in this. So, a landlord cannot be held that he has no possession. It may not be a physical possession, but in a Khatian, the landowner owner's name is also in a Khatian is mentioned, and tenant's name is also mentioned. So it cannot be held that if there is a tenant, the landlord cannot have possession. It may not be a physical possession. Physically, the tenant may cultivate the land, but it can be held that landlord also have the possession. It may be a constructive possession. Physically, the tenant is present. This is mentioned in the pleading, the pleaded case, that he was already an existing tenant, occupancy tenant, and subsequently he purchased from his landlord. That was the case of the petition, and that is mentioned in this paragraph, my lord. That paragraph number 8 in WS, the defendant mentioned that he was in possession, being a tenant, And in the sale deed, it is mentioned that the landlord handed over the possession. That is my clarification regarding this document. Now, if we believe the version of defendant in WS supported by an affidavit, then the contents of Exhibit A is to be considered as false because both the persons cannot be possession of sweet land at the same time. In the Khotian, both persons is named there. But the Honorable Court held that both persons cannot be the possession at the same time. The contradictory averment of defendant in WS to the recital of Exhibit A document itself nullifies the claim of the defendant and indicates towards the fact that Exhibit A document executed by defendant number 4 in respect of sweet land in favor of defendant number 1 is illegal and void document. So regarding possession, my lord, the evidence of no witnesses is discussed. Without discussing any evidence of any of the witnesses, the possession is held to be, my possession is held to be not I am on possession. And regarding title, your lordship has already found that the Exhibit 1 proved that my predecessor has the title. And from my predecessor, it is admitted that one of the Patadari. So both the findings are perverse regarding title and possession. So in the light of our discussion, I am constrained to decide this point in negative and defendant appellant. So in the backdrop of the above discussion, I am of the considered opinion that learned Munsif has rightly decreed the suit in favor of the plaintiff. Accordingly, judgment and decree passed by the learned Munsif is hereby upheld. So your lordship, regarding the evidences, may I draw your lordship the evidence of PW1? PW on the LC. I have annexed the PW1, your lordship, in my name of appeal, PW1 page 66, my lord.
In page 66.
Page 66 of my memo of appeal. 66.
Yes, on affidavit is there.
Page number 66, Chief, my lord. Chief, I think the chief is also required, my lord, maybe.
So in page 66, we have the deposition of one
PW1.
Virendra Chandra, that is PW1.
Yes, he's the PW1.
So here we have the affidavit.
PW1, I think it is required to be, my lord.
Pardon?
It is required to be, my lord. Read over.
But it's already here.
It's well, but my lord, he has regarding something is there because my lord substantiate his inability to substantiate his inability regarding the production of the any rent document, or to his landlord. He
So
has
from PW1, what do you want to show?
PW1 has admitted that my vendor's father is one of the Pattadar in the Khotian, and also that he had pleaded one thing that one of the and that he could not adduce except one rent receipt. Other rent receipt he could not adduce because that was stolen. He had mentioned. some dacoity, someone has taken away, but he could not adduce anything to prove that regarding the document, regarding his plea of dacoity, that he has lost the rent receipts. That is called Farox in this case.
After docating, whether he had lost any FIR?
Yes, no, did not there in the evidence. He could not adduce any proof that
No, you have submitted that there was a dacoity.
he has
In that-
submitted. He has submitted that he
In
lost.
that case, whether he lost any FIR?
No, my lord, nothing is there. That is on evidence, my lord. So, and regarding the, my lord, my vendors, predators was there. That was also he admitted in this documents, in this his evidence in chief.
In evidence in chief also, in which
Yes,
para?
evidence chief he admitted.
That portion
which
is
para?
not correct, Lordship. Exhibit 3 is the carbon copy of the said Ejahar.
Carbon copy, my lord, it is not a proof. It is not proved by original, my lord. That
It
is
was
my,
exhibited, Lordship. Exhibit.
that is my lord, without any GD entry, without this. So, my lord, I think the evidence is important to govern. Because the
There's
entire
concurrent findings, you want to discuss on the evidence also?
evidence, my lord, evidence, my lord, because it is a perversity. One of the, my lord, this substantive question of law is perversity, my lord. And the, my lord, first substantive question of law also depends on the substantive question of two, my lord. Because, my lord, in the evidence, if the evidence was discussed, my lord, it also have a bearing on the first substantive question of law. So without evidence and
In civil cases, whether there is, the requirement is already there, but whether there is any requirement for discuss all the evidence of the PWs or DWs,
no,
like the criminal cases.
yes,
Is
my
there?
lord, not a single evidence is discussed. The defendant's, specifically the defendant's case is his witnesses. The defendant's evidence also not a single evidence is discussed. Not a single evidence witness is discussed. So without discussing any of the witnesses,
In Lordship, trial court, first appellate court both discuss the evidences, Lordship. First appellate court discuss about the written statements and the exhibits. Trial courts categorically discuss the DW statements, Lordship. And my learned friend is pointing out that PW1 admitted that due to dacoity, I have lost some documents. So I have lost an Azahar. So except exhibit 2, I could not adduce further rent receipt to prove my tenancy for the entire period. That is the only case, Lordship. My learned friend wanted to say that part from the PW court.
and also, my lord, in the exhibit 1, your lordship will find in the record, exhibit 1, it is mentioned in the document on which based the decree was passed, the Khotian. In the Khotian, the landlord's name is Rabindra Chandra Das. This is my vendor's father's brother, and other 5 persons mentioned.
Primarily on the issue that the father of the vendor, father of your vendor was a patta holder or one of the person whose name was reflected in Khatian. That is your case.
His name is not
So
reflected.
pardon?
Is not reflected in the Khotian exhibit 1, but it is mentioned Rabindra Das and 5 others, and in the evidence of the PWs, it came, my lord.
No, from where you are saying that
From the
you
evidence, from the evidence,
the
my lord.
oral evidence.
Yes, my lord. He
No
admitted,
other document.
no other plaintiff
That
admitted.
the vendor, father of your vendor was also a Khotian holder or whatever. In that case, you don't have any documents. From the
Plaintiff,
oral evidence you're
yes,
saying.
plaintiff admitted. Plaintiff admitted in
He admitted.
He admitted, my lord. So since he has admitted, I need not prove, my lord, that it is admitted by the.
Oh.
So for which, my lord, the evidence is required to be read over.
That part we are admitting, Lordship, that his vendor's father and one Ravindra are the original owners. From them, we were the tenants under them, Lordship. That part we are admitting. We are not denying that his vendor is not a pattada, Lordship. Maybe today it is not possible to conclude, Lordship. Otherwise, very simple case, Lordship. I am a tenant and later on, Lordship, on the basis of my tenancy, After acquisition, government granted Khatian in my favor.
In your favor.
That Khatian was not cancelled by any authority within the stipulated period. There is a period. There was no objection by any of the party. So Lordship, it remains.
No, no, Brunei. I do. Now, what to say about your date? It remain will part heard because I have heard and I have noted down your submission also.
Well,
But the question is that you want any date, fixed date here? It will be obviously in the month of November.
November, and Lordship convenient.
If
State is
possible,
also
Lordship, within October, we can.
October may not be possible. There are a lot many matters are there in the month of October. Maybe in the first week of November. You are depending.
Yeah.
You are for the state respondent or?
4 and 5.
Okay. 2, 3, 4, and 5.
Okay, after the filling laws being applicable, this land has the government took them over and then approved it.
On 6th or
So
11th,
here-
my lord. On 6th or 11th. No,
6th.
11.
Oh, 6-1 matter is there. From
11 May,
the council is coming from Kolkata. We have fixed it.
11 May.
11th. It's a Tuesday, na?
Yes.
It can be then 11th. It will Mr. Adipati and Mr. Godasai is for the status. Okay, we'll keep it as a partner.
Public.
So the applicant has concluded that
No,
I have not
they
concluded.
have not
It will
concluded.
take another 1 hour. Then Lordship, I will take only half an hour.
No, that's what I want to submit. You
He is
do
the
not read
applicant,
the
Lordship.
whole evidence of PW 1, 2, 3. This is not
I will,
required.
I will,
You
only
be
important,
required
important.
only the important or the
Important.
relevant, if any relevant thing is
Yes.
there, that can be only pointed out.
Yes.
Otherwise, it's not.
Yes.
required.
So then, what will it say? What is the evidence say? Section 91.
Documents will prevail.
When,
Documents, evidence,
documents
document
are
evidence
there.
prevail over the yes.
Say no longer relevant.
It does
Lordship,
not
he-
mean
he
that
is
the-
the-
it-
he is
Civil
for the
matter
appellant
document
and-
prevails. or
Yes,
the-
Lordship,
it
he is
there.
for the appealant and concurrent pending. It is obviously will take some time, Lordship, to satisfy the court, Lordship. Against concurrent pending, my learned friend is arguing.
Obviously, it's a concurrent fine.
Yes, Lordship.
Okay, then we are fixing it on 11th of November. Let us try
Okay.
to read it. Apa yang kamu lagi? 11th of November, telephone matter. You just do one thing. If in the 11th November, if it is fixed, suppose, or it will come definitely.
Part-
by the
part-
time.
come.
So just remind us so that your matter can be heard, giving a priority. Because otherwise, what will happen that if any other matter hearing is there, then obviously again it will may take time or again.
Fix it at 2 p.m. So that we
It can be,
Yes,
at 2. Okay, at 2.
Public.
2 p.m.
That-
will be all right, I think.
Lordship.
Don't repeat all these things because I have already recorded. Simply, if you want to submit anything from the deposition of the PWs or the DW, that
Public.
problem.